I have 3 announcements to make before we commence with the proceedings of the day. Arrangements have been made with the media that there will be, from today, they will be allowed, once the candidate is called in and takes his or her seat, to take photographs for just a minute. And once they are done, they will excuse us, and then we'll proceed with the business of the meeting. Then the second one is that due to circumstances beyond our control, we'll have to take our lunch adjournment today at 10 to 2 before load shedding kicks in at 2. The hotel does have backup generator, but we need to take a break so that to allow the IT people to set up, to migrate from, power to generator, whilst we are having a lunch. Then we will resume at 3, and then again at 1600 or 10 past 4, we will have to take another short adjournment, forced short adjournment, because another bout of load shedding will kick in at 1620. Our tea adjournment at 10 past 4 will be for 15 minutes only. And then at 25 to 5, we will reconvene and continue until we finalize today's interview. Thank you.
Acting President, it's Glynis Breitenbach. Good morning, sir. May I say something, please?
Yes, you may, Commissioner Breitenbach.
Thank you, sir. I just want to point out that I'm in Cape Town and our load shedding is scheduled for 8 o'clock tonight. So I will lose connectivity probably at 8 o'clock tonight.
8 o'clock tonight, you say?
Yes.
Hopefully will be long done by that time.
Will be done at 3, Commissioner Breitenbach.
Thank you. At this stage, will the candidate be brought to the venue? Thank you.
Good morning, everyone.
Morning,
Now the
President
paparazzi is
Maya.
just making me nervous now. Are they all wearing their masks though? Okay.
Thank you very much. Good morning, President Maya.
Good morning, Acting President Pedze and commissioners.
Are you well this morning?
You don't want to know the answer, DP. But let me say I'm as well as can be in the circumstances. And I hope you won't be too rough with me.
I will allow you a few seconds to settle down and take a deep breath before
No, I'm
we...
settled, DP. Let's do
Thank
this.
you. As a member of the Judicial Service Commission yourself, shall we place on record that you know each and every member of the commission seated around this table?
Yes, I do. I don't know what to call you. Let me call you DP. Then I won't confuse myself.
And speaking for myself, I've known you for some, 30 years or so?
It's been a lifetime.
You are also one of the 4 candidates nominated by the President for the position of the next Chief Justice of the Republic of South Africa in accordance with the dictates of the Constitution.
Yes, DP. DP, can I ask a favor, please? This is something I should have mentioned at the outset, just for housekeeping. It was just brought to my, well, I was reminded only this past Friday of a farming cooperative that my family and I incorporated many years ago. We had lofty, ambitions to farm our rural land, our family's rural land. But it never got off the ground, and I simply forgot about it. I know I should have mentioned it in my application form, and I just forgot, and I do apologize for my carelessness. It was just that tiny aspect.
Thank you, President Maya. Point noted.
Oh, I may mention that none of us have any intention of farming, so I've already given an instruction for his deregistration.
Thank you. First and foremost, a word of welcome would be appropriate to this session of the Judicial Service Commission.
Thank you.
And might I indicate up front that it is our onerous duty and responsibility to interview you, as with all the other candidates, with a view to advising the President in due course as to who we consider eminently suitable to be appointed as the next Chief Justice of the Republic of South Africa. You were born in 1964 in the rural town of Solo, Eastern Cape.
Yes, DP, my mother's hometown, which is where she and my dad met.
And for the record, would you please confirm that you are a South African citizen by birth?
Yes, I am.
You are married with 3 adult children,
Yes, DP.
and you hold 3 degrees, namely BProc, LLB, and LLM.
Yes.
You were appointed to the bench at a youthful age of 37, I think it was,
35, DP.
35.
Yeah.
And when was that? What year was it?
That was in 2000. Sorry, I was actually 36. I just started acting at 35 and I never went back to practice. I stayed on the bench until my permanent appointment.
Thank you. You are currently the president of the Supreme Court of Appeal, having been appointed to that position in 2017.
Yes.
Having looked at the bundle of documentation that you submitted, I see that you have come a long way to reach your current position. You started off as an assistant clerk in a firm of attorneys in Umtata.
Yes, DP. Best memories of my career.
And before you were called to the bar, you had stints with the Department of Justice as assistant legal advisor.
Yes, DP, working in the State Law Advisor's office.
And also as a lecturer, law lecturer at the University of Transkei, as it was then known.
Yes.
And in the run-up to the first democratic elections, you were associated with the Independent Electoral Commission as an investigator.
Yes, DP.
Then your acting stints, as you have already mentioned, commenced in 2005. And you never went back to practice again because you were permanently appointed as a puisne judge in May 2000.
Yeah, in 1999, July 1999, you said 2005, that's when I started acting in the SCA.
Oh, I'm sorry.
Yeah.
Yes. Thank you for that correction. And whilst you were a puisne judge of the High Court, you had sojourned in the Labor Court and thereafter the Supreme Court of Appeal in 2005, acting in the latter court until you were permanently appointed in 2006.
Yes, DP.
What special attributes did you have that made those who invited you to act both in the High Court and also in the SCA, ending up snatching you for good? That is,
I like that turn of phrase. Well, simply, DP, I think it's just my industry and my personal qualities. The person who got me started on this path is Advocate Dumisa Nzebeza, who was at the time already, he had moved from Transkei to Cape Town, but still used to come and do cases in the Transkei division. So I would meet him in motion court, and I think he saw how I performed there, and he kept saying we are looking for women acting judges in that division. Please let me forward your name to the powers that be. That way, JP Edwin King and his deputy, the now JP Hlope. So that's why I say it must have been my industry, and he also knew me personally, and I dare say that my best qualities, in addition to hard work, are just my honesty and integrity. And he must have, well, he and the others who then subsequently got me onto the bench must have recognized those qualities in me. It's those three qualities, really.
Yes. And I can also attest to that because whilst you were at the bar, I briefed you on a number of occasions.
Indeed, you did.
And while still practicing as a member of the bar, you took up membership in various legal organizations, and that continues till today.
Yes, DP. Well, at the time, it was the professional organizations. We had NADEL, which was not very active in those days, and BLA, which was, raring to go doing things. So my interest in NADEL quickly fizzled out, and I stuck mostly with the BLA.
Have you received any awards or honors from lawyers' organizations, other bodies or institutions here at home and abroad that you can share with the Commission?
I have quite a few, DP. Let me start with the academic ones. I was awarded a Fulbright scholarship. That's how I managed to do my master's in the US back in those days, which was not something easy to come by. And then when I was there, I joined, well, it flowed from my, it was one of the benefits of that scholarship. I became a fellow at Georgetown Law University in their gender department. And that fellowship is an honor in itself. And later, I became a Commonwealth Law Foundation fellow. But, life always catches up with us at awkward times. I was supposed to have gone. It had a program for its fellows, induction program. They take you to a few international Commonwealth countries to observe relevant practices there. But unfortunately for me, I fell pregnant. I was already on the bench. I fell pregnant with my last born, and the time of induction coincided with the time of the delivery of the baby, and much as I wanted to go, I could not. So my interaction with them was rather limited and only electronic. I have been awarded, at professional level, I've been recognized by two women groupings, prominent women groupings in the legal field. SAULA, which is the South African Women Lawyers Association, and a Women Judges Association, of which I'm currently president, the South African chapter of the International Association of Women Judges, which have, awarded me, recognition awards twice, because, they said because of the work I have done to promote gender equality and my contribution to the jurisprudence of our country. I have I've even been awarded a recognition award by the Eastern Cape Business Chamber in the category of law. Recently, My alma mater, one of my alma maters, Duke University in the USA, awarded me a very prestigious award at the height of the COVID-19 pandemic. That was one of the highlights of 2020 for me. They chose me as their international law alumni for 2020. And incidentally, they recognized 2 other South Africans in that year. Former Deputy Chief Justice Museneke for his work in the human rights area, and a woman who's a former, one of the former Chief Justices in the US, Justice Margaret Marshall, who was born and bred here, but then studied here, a Wits alumnus rather, but she left for the US and made a big name for herself there. I have been awarded 3 honorary doctorates by 3 universities, Walter Sisulu University, Forte, and Nelson Mandela University, of which I'm very proud. I think that's about it, DP. Oh, and maybe I should mention the fact that I was recently appointed as Chancellor of the University of Mpumalanga, a feat of which I'm very proud, which is an honor also.
Thank you, President Maya. Your CV makes reference to the fact that you served as an acting judge at the Constitutional Court for 2 terms in 2012.
Yes, I did.
Which you have confirmed in your documentation. How did you find the experience at the Constitutional Court?
I thoroughly enjoyed the intellectual rigor that came with the work, the collegiality in that court, to the extent that when a vacancy arose shortly after my acting stint, I made myself available, applied for the job, along with Deputy Chief Justice Zondo. I was recommended, I was one of those recommended by the commission, but there was one vacancy and I did not make the president's cut. It chose ACJ Zondo. But it was an exhilarating experience, which I thoroughly enjoyed.
You also had the rare honor and privilege to serve as an acting judge of appeal in Lesotho and
yes,
acting judge in the Republic of Namibia.
Yes, DP, but perhaps I should explain those were just one-time, events, which usually happens. The neighboring countries are not well capacitated in terms of their judiciaries, and frequently they make use of South African judges. So in both instances, I was one of senior judges who had been asked to go and deal with sticky cases that none of the judges there could deal with. In Lesotho, it involved the perennial problems with their Chief Justice, and in Namibia, it's a case that involved a sitting judge in their Supreme Court, something to do with a servitude over land he occupied, a long-running problem that had been sensitive. So that's how I came to work in those 2 countries.
Like the previous candidate, I do not propose to take you through your judgments because I believe that your record speaks for itself. A fact confirmed by various lawyers, professional bodies, and organizations. But I just have this one question for you.
Yes.
What inspired you to write the judgment in the case of AfriForum and UNISA in both English and isiXhosa, which was, as far as I'm aware, is the first ever in this country?
I was just thinking about that this morning. It is actually a former commissioner of this body who who ignited my conscience about cultural issues of cultural identity and our languages, which we are losing. I mean, our children hardly speak our language. In fact, us do not speak our languages. We can not even finish one sentence, in our home, in our mother tongue, without infusing English or some other language. So I was inspired by a question he had put to me during one of my interviews about what we can do, to save our dying cultures. And I had, always read constitutional court judges written, especially by Justice Froneman, who used to make a point of having dual, language judgments whenever the opportunity arose for him, and I would envy that so much. And when this judgment came along, this matter came along, I thought it was a perfect opportunity to write in isiXhosa. And I did, but we sat together in the matter, and I had indicated at conference that, colleagues, I'm going to do something that has never been done before. I'm going to write this judgment in isiXhosa, and the looks on all your faces, I could write a book on them. But we had that matter in the last term of was it 2019? But it took a while to produce. It was a tough exercise. It came out about 5 to 6 months later, which is very late. But because I'd made this pledge that it needs to be done, it was a long judgment, and the jargon, legal jargon, mostly does not have equivalence in normal parlance, to the extent that I had to enlist the assistance of an interpreter, a closer translator, who checked my first effort and made significant changes there too. But I also, when her draft came back, I insisted on making my own, infusing back my own understanding of the language. And you also assisted DP as a first language isiXhosa speaker. And we managed to produce, I think, a solid product, at least insofar as language is concerned.
Thank you. You also made time to participate in extrajudicial work with various organizations and institutions of higher learning, both in South Africa and abroad.
Yes.
And you have delivered several papers, both here and abroad.
Yes, DP.
Your nomination by the South African chapter of International Association of Women's Judges received overwhelming support from various organizations, associations, universities, both here and at home and abroad, and other bodies, even individuals, too many to enumerate.
As far as New Zealand, DP, I suppose women all over the world want to be seen, heard, and acknowledged. So this just roused a lot of interest, straddling continents.
Thank you. President Maya, we have now reached a stage where I must afford you half an hour to tell this commission and the nation at large how you see the role of the Chief Justice in our democratic state, and also share with us your vision of a functional, efficient, accountable, and independent judiciary in the Republic of South Africa.
Thank you for the opportunity, DP, but I have a special request to ask, which I plead should not cut into the 30 minutes, to first give a brief report on certain undertakings I made to this commission during my interview for the position of SCA president in 2017. I won't take long, I promise, but don't start timing me just yet. May I do that?
I will allow you that opportunity, but before you make your presentation, I just want to add this. Whilst you are making your presentation, will you also touch upon the myriad of challenges facing the judiciary at the moment, both in terms of the tools of trade, conditions of service, delays in rendering judgments, and the like?
I have a long list, DP, and I'm scared that the 30 minutes you have allocated me may not even be enough, but I'll do my best.
This is your opportunity.
Thank you, DP. In 2017, the Commission had asked me to describe the vision I had for the SCA, and in answer, I said I was inheriting a very efficient institution staffed by diligent and experienced judges, and that, in my view, only a few tweaks were needed to improve it. I then identified 3 areas that comprised my to-do list. My first target was gender diversity, and I lamented the shortage of women judges in that court and other courts. I'm very proud to report that with your support, commissioners, in the 2 rounds of interviews for judicial vacancies at the SCA, 5 in 2019, and another 5 vacancies in October last year, we were able to achieve the appointment of a total of 6 women, 2 colored, 1 white, and 3 African. One of the 4 male judges we appointed, of the 4 male judges we appointed, 2 are African, 1 is colored and from the Cape Flats. And I always mention that when I speak about him because he comes from a really, disadvantaged background. And the last male is white. And now, please listen carefully, Chair. There are currently 23 judges in your court, the SCA. 11 are women and 12 are men. So we are fast closing the gap, and this is despite the fact that we keep losing our women judges to the Constitutional Court. The 8 most senior judges at the SCA are black, and 5 black women judges are presiding over cases as we speak. This is against a starkly different picture of the SCA I found in 2005 when I started there. And the project to transform the court still continues. The SCA has another 5, I think, vacancies to be filled later this year. And there will be, I promise you, there will be no shortage of women candidates in that round as well. My second target was the lack of collegiality in the court. I have no doubt that you, Chairperson, will vouch for me that we have vanquished that demon. You yourselves, commissioners, have had various candidates who've appeared, before you, speak about the positive changes that have taken place in that court under my watch. My third target was fair allocation of work and judgment, writing allocations that promotes skills of transfer of skills and ensures that all SCA judges get a chance to write judgments in matters of substance. Again, Chairperson, I'm sure you who shares the responsibility of allocating work to our colleagues down there will confirm that that project is running smoothly. So in sum, Chairperson and commissioners, the SCA has turned a critical corner in the last while. It has changed its institutional character for the better. All is well there as can be, although it is, it's ongoing work. We can never relax. And I dare say that I have delivered on the promises I made before you 5 years ago, well, about 5 years ago. Now to my vision for the judiciary. As I warned earlier, Chair, my wish list is long. And to make sure that I use my 30 minutes efficiently, I've prepared a timed note, which, with your leave, I will read so that I get everything in, and hopefully the commissioners will help me flesh some of the things out during open questioning. But before you start timing me again, please allow me to first apologize to all my colleagues in the judiciary that I express views on the state and path of our institution and our role in a changing world and how I think we can improve things without the benefit of their inputs. South African judges have not had a meeting under one roof to jointly discuss the state of the judiciary, its challenges and needs since 2009, and yet so much has happened within the institution and the world around it. The sharing of views, at that kind of meeting would have enriched my one's perspectives on these matters tremendously. Well, I apologize because I'm one of the leaders of the institution and one of the culprits for the omission. But let me say this, I and many, if not all, our colleagues fervently hope that convening that judges' meeting, for which judges have clamored over a long period of time, will be the first order of business for the new Chief Justice. Now, I start with my understanding of the role of the present-day Chief Justice because the job has evolved significantly since the days of Chief Justices Chaskalsin, Langa, and even Ngobo. It's multifaceted, it's extremely demanding, but it's possible to juggle all the many functions which it entails because there's ample support around a Chief Justice, a South African Chief Justice, in the office of the Chief Justice, the heads of court cluster, and the judicial officers themselves, because they are highly educated and experienced professionals. I think it's important to highlight at the outset that a Chief Justice and the heads of court are not bosses of anyone. They are only first among equals, and that demands collaborative and consultative leadership. There is a great wealth in occasional lehotlas of the entire constituency, as we experienced until 2009. I can't overstate that point. The core function of a Chief Justice Chair, in my view, which is shared equally with all other judges, is to sit in court, preside over cases, and produce judgments expeditiously, and her vote in the adjudication of cases carries the same weight as those of her colleagues. Then follow the additional numerous and unique responsibilities that attach to the position. The Chief Justice is responsible for the administration of the Apex Court and exercises final authority over the functioning and management of all courts, in terms mainly of Section 165(6) of the Constitution and Section 8(2) of the Superior Courts Act. Now, these duties entail, among others, oversight of all the courts, the Office of the Chief Justice, which is a national department, chairing judicial institutions such as this body, and the South African Judicial Institute of Education, swearing in various public officials and convening meetings in various constitutional bodies, the list goes on, and generally representing the South African judiciary in local and international judicial formations. She is the face of the institution. I think it's important to note that our country has been through a lot in recent times and faces many serious challenges. So the need for an impartial, independent, effective, accountable, responsive, and cohesive judiciary has never been bigger than it is now. Whoever is appointed for this position bears the responsibility of ensuring that the institution remains strong, retains its integrity, and firmly executes its role of protecting and promoting the Constitution and the law, so that our country, especially the poor and most vulnerable members of our society, are guaranteed access to justice. It must be someone who is equipped to inspire stability and cohesion within the judiciary itself and inspire public confidence in the judiciary. Fortunately, there is no need to reinvent the wheel, as almost all the fundamentals for an independent, impartial, and efficient judiciary are already in place. The blueprint, which includes the establishment of the judiciary's own department in the OCJ, and a training institute for judges training and continuing education, run crisis, as some have lamented. Yes, it is not perfect, but there is still a relatively, maybe not even relatively, there's still an efficient system of administration in place. But there's a lot of work to be done, Chair, to get the institution working optimally to execute its constitutional mandate. Now, some of the key issues that I've identified as requiring attention, some very urgent attention, are the following in no order of importance. Among my top worries is the report of the 2021 Afro Barometer survey, I think, that the public's trust in the judiciary has declined. As we all know, loss of confidence in the judiciary does not augur well for the rule of law and our democracy. And I think that this is something that needs the attention of the judiciary itself to do an introspection and check if we are to blame for this change of attitude towards the institution. And of course, the state organs who are enjoined by the Constitution to protect and support the judiciary must assist us. I am happy to note that the heads of court, led by Chief Justice Mogoeng, recently had a very fruitful meeting with the Department of Justice, the Justice Portfolio Committee, which clearly showed the legislature's willingness and enthusiasm to support the judiciary. And one hopes that those engagements will carry on with frequency as we go forward, because the challenges are too big and we all need to work together for the good of our country and her people. And South Africans at large must assist too, because this institution is their asset. This is their institution. Secondly, Chair, there is the challenge you mentioned as you were, alerting me to your own list of issues that cause you sleepless nights, the challenge of delayed judgments, which is just inimical to the efficient and accessible judiciary that delivers judgments expeditiously envisaged by the Constitution. This has proven such a big challenge for the institution, including in the apex court, unfortunately. But there is not just a glimmer. There is significant hope that we can turn things around in that regard, because a number of courts, manage to execute their judicial function efficiently. And it seems from my observations and investigations and inquiries that firm leadership, strict implementation of the set norms and standards, and strict case flow management is the cure, because courts with those practices have good outputs, as the annual performance report that the OCJ prepared for us and was presented by the Acting Chief Justice recently showed. Now, I'll spend a bit of time on the Apex Court Chair because of its importance. I watched some of yesterday's proceedings with Justice Madlanga, and I heard the issues raised with him as criticisms that have been leveled against that court, and I have a few ideas to share on how things could be improved there. Sorry, I'm getting cold. Yeah. I think it's adrenaline that made me warm when I walked in. Maybe, yeah, I see that Commissioner Malema is quite upset. Can we turn the aircon down a little bit? Thank you. Thank you, Chair. I state at the outset that I've not been at the Constitutional Court in about a decade now, but I have followed its progress over the years, and I keep in touch with many of the colleagues there. The judiciary's annual performance reports show that the court's workload, especially in relation to applications for leave to appeal, has indeed grown exponentially since its jurisdiction, that is the court's jurisdiction, was increased in 2013. But interestingly, when one checks the court's appeal and new up statistics between 2015 and 2017, when the increased jurisdiction was already in place, those statistics appear to be roughly the same today as then, early on. Up to around 2017, and I've checked this carefully, there were no significant delays in the court works output, but it has lessened significantly in recent times. Now, in my view, the work done in the Constitutional Court is similar to the work done in the SCA, and the rules of the two courts are not dissimilar. The main difference is that the Constitutional Court sits en banc, which of course must slow down the court's processes to some extent. Now, I do believe that the manner in which the SCA operates to achieve quick turnarounds, for which it's well known, might work there too. And my conversations on the subjects with my colleagues there who came from the SCA confirm that belief. It seems to me that what is needed in that court is good organization and time management, just working smartly, and firmly instilling the SCA culture that you do not even leave Bloemfontein at the end of the court term until you have at least prepared a decent draft judgment in all the matters heard during that term, so that those matters can be finalized at the latest at the beginning of the next term. It seems to me that a review of the Constitutional Court's work practice manual is absolutely necessary for the reasons you pointed out yesterday, Chair. It sets out the time frames that it sets out, I do believe may contribute to the cumbersome, some of the procedures are cumbersome and they cause time lags that can be chopped down. But I must say that it was heartening to hear Justice Madlanga report that there are moves to address that issue, and I know for a fact that there are contemplated moves to amend some of the court's rules, especially relating to the operations of their general office to enhance the court's efficiency. But In that regard, I should point out a seeming anomaly that may hamstring that process, because according to my research, Section 29 of the Superior Courts Act, which provides for the making of the rules of the Constitutional Court, is yet to be proclaimed, unlike Section 30, which provides for the SCA and Uniform Court rules, which is operational. Minister Lamola will I'm subject to correction. I may have been overtaken by events, but according to my research, it still remains, unpromulgated, and that may perhaps be an issue for you to look into quickly if the rules of that court are to be amended in the short term. Now, I start with appeals, Chair, and my first step would be what we do: to set matters down for hearing only when they are ripe for hearing and the record is complete. When I acted at that court, process in the matters, already set down, trickled in bits and pieces until the very day of the hearing. And sometimes even during the hearing, you'd be getting things being submitted from the bar. And I'm told that by colleagues there that situation has not entirely changed. Now, that is not good practice, especially in a senior court, because it does not allow the judges a proper opportunity to prepare for the hearing so that they can engage counsel on all the issues, and in turn, it hampers the speed with which judgments will be delivered, because the judges are catching up with the issues after the hearing, and sometimes are even forced to ask for further submissions from the parties at that late stage. And the practice, may I just add this other practice, Chair, of holding conference directly after a case hearing, which the Constitutional Court previously used and the SCA still uses. It has great merit because it forces thorough preparation by the judges before the hearing and allows the sharing of views directly after the hearing while the debates are still fresh in the judges' minds. And it can be determined quickly if there is going to be disagreement, and the judges can start engaging meaningfully towards that direction and immediately start writing the competing judgments, all shortly after the hearing. I must confess, though, that, as you know, Chair, that the SCA also waits for the allocated scribe to produce the main judgment before work on a dissent, if there's going to be one, can start. But I think that is perhaps something we can also consider, as it would improve our turnaround times even more. So my point in sum is that holding conference directly after the hearing saves time in the long run. The comprehensive conference that is already in place can of course be retained. It is necessary, but the first one is important. Now, about the troublesome applications for leave to appeal, there appears to be a general feeling in that court that requiring all judges to be part of the quorum to deal with applications for leave to appeal is unnecessary and time-consuming, and that hearing them in smaller panels of, say, 2 or 3 judges, as the SCA does, would allow the duty judges to dispose of an application for leave to appeal by dismissing it, and that would free up time for judgment writing. And where the duty judges consider that the matter should be set down for hearing, or they disagree, or for any other good reason, they would circulate a memorandum to the rest of the members of the court for a final decision on whether the matter should be set down. That would, of course, necessitate an amendment of the quorum provisions of the court in Section 1672 of the Constitution and Section 12.2 of the Superior Courts Act. that prescribe a minimum panels of at least 8 judges. I favor the amendment approach, I must say, as it would also formally address the unfortunate phenomenon of evenly split judgments with no ratio that we have seen come from our apex court. That said, litigation is increasing exponentially. South Africans have become very litigious. And there may soon come a time when the Constitutional Court needs capacity. It may be now. As I understand it, that court can comfortably house 15 judges today, and a constitutional amendment increasing the number of judges, if that route were to be adopted, would be necessary, of course. Now, ideas which I find appealing have been bandied about, that such a development, that is employing more judges, coupled, of course, with a quorum amendment to at least 7 judges instead of 8, 7, which I still think constitutes a fair number, a fair-sized panel of judges, that would allow 2 courts to sit on more times than the current twice or once a week that we see at the Concord, and increase that court's output. And it would still be possible to have the traditional big panel of 11, if need be, for the traditional important constitutional matters. Or collapse what Minister Lamola asked yesterday, collapse the Constitutional Court and the Supreme Court of Appeal into one court, as my colleague Justice Matopo suggested here in October, and strengthen, that's possible. We could strengthen the appeal processes in the High Court, the full bench sittings, and that, in fact, would remove a whole layer, expensive layer, in the appeal process, and actually enhance access to justice. But we can debate these ideas further at a more appropriate stage. The third point, Chair, is the project of court modernization and digitization, which is Chief Justice Mogoeng's baby, to enhance court efficiency and speedy access to justice. It must now be implemented fully in all courts. I'm sure Minister Lamola will agree with me. We have seen its importance and efficacy with the introduction of virtual court hearings hastened by the COVID-19 pandemic, especially for civil cases. The development of the court online solution, which will improve the management of court records and minimize loss of critical documents in courts, must be prioritized. Case lines, which allows for the filing of court process by uploading it electronically and dispenses with the need for paper records, is still a pilot project used in the Gauteng division, and with JP Mlambo's help, only partially for petitions in the SCA. We want to extend it to appeals proper now. And I know for a fact that there are other divisions that have been clamoring for its rollout to their courts for a while now. Next, Chair, is the fact of the talk of creating a single judiciary that started, I think, during former Justice Minister Penuel Maduna. That was many years ago. I would push for its implementation and bring all our courts under one roof in the shortest term possible. We all know that there are many serious challenges in the magistracy. And fortunately, the minister and the chair of the Justice Portfolio Committee, who know all about these issues, are here. We just heard in the media a few days ago about Commissioner Magwanisha's anger at what he found at Palm Ridge Magistrates Court, which has no recording transcription machines to record court proceedings. Imagine what will happen if those matters The judgments in those matters are taken on appeal or review. It has no CCTV equipment which allows child rape victims to testify in safety, because the Department of Justice, unfortunately, well, that's what is reported, unfortunately allowed the relevant contract to lapse without making alternative arrangements. These problems and more are experienced by the magistracy across the country, and that sector of the judiciary has asked to be linked to judges under the OCJ's care so that they too can benefit from the individualized attention that judges get and experience the judicial independence which the judgment in Van Rooyen said many ages ago they are entitled to, because they are judicial officers and not civil servants as they are currently treated. The transformation of the judiciary remains a big challenge, Chair. Yes, great strides have been achieved in terms of rape. Did I say rape? Race? Well, I live in South Africa. But gender diversity still remains a big challenge. You know, there's this big misconception that the judiciary and even the professions are more transformed in terms of gender than they actually are. It is important to clarify that women are still hopelessly underrepresented in all spheres of the law, and it remains critical to close that gap and have a substantial number of women all the way up to leadership, which the magistrate, you know, strangely has impressively achieved. We must just find out what has been done there. So that example of the magistracy tells us that with the right will and determination, it is possible to achieve meaningful gender equality in this institution and elsewhere. I find it most heartening that my reminder to the Chief Justice during my 2017 interview for the SCA presidency about the program to fast-track women into the judiciary, started by former Justice Minister Bridget Mabandla, at the instance of the South African chapter of the International Women Judges Association many years ago, when I was asked the perennial question of how we can improve gender diversity in the institution, has finally been resuscitated, and I am informed by the SAJ that it will start in earnest in July. That will be a game changer if one considers that all the women that were candidates in Minister Mabandla's pilot program became judges. Three of them sit at the SCA. One of them was a JP, Justice Molemela now, Judge Khwele, Judge Somanaidu. I have Judge Nicholson, appeal judges who came from that program. Imagine if we had not allowed it to die when the tenure of Minister Mabandla terminated. We would be far, but it's never too late to do the right thing, I suppose. So, yes, that program is coming into action, but we must not stop doing the other things we've been doing in the meantime, agitating for women to be given quality work in the professions by the state attorney. You know, that can never be overstated. Government must give, black lawyers and women lawyers quality work so that we have a pool from which we can tap when we look for judges. And we have people who are ready, who have had experience in these niche areas of the law, commercial law. When they go to the bench and we do not get these comments, these, painful comments that the quality of judgments, is being eroded. And that comes from the full question is that the judgment, the quality of judgments is becoming poor because of transformation, because you are getting more black people into the system. Now, these chickens come home to roost at some stage. So give people a chance, give them an opportunity to get the adequate experience so that they can do a proper job when called upon to do so. We are not going to wait. All of us here, the black people, are products of Bantu education. We did not get the best education there was, but despite all those odds, we managed to get ourselves somewhere. It is our kids, the generation that has been able to go to model C schools and private, fancy private schools, that have been able to compete neck and neck with the other races. And black children have proven themselves there that they, black people are as equally gifted as other races. But we are not going to wait for that generation to rise to institute transformation. We have to do it today, yesterday actually. I'm sorry, I got a bit emotional there. So get women into the judiciary, and when they get into the judiciary, give them the same opportunities as their male counterparts, who, by the way, are not better intellectually endowed than those women. Now, linked, let me calm myself down, Chair, this upsets me. Linked to gender diversity, Chair, are concerns that have been raised by, among others, advocacy parties, that the judiciary cannot achieve gender equality and equity when it does not even have policies that accommodate women's challenges. For example, the judiciary, and I took it for granted that we did, I learned this only recently. The judiciary has no anti-sexual harassment policy. As if we live, we come from this bubble somewhere, we are not part of society. We don't experience the problems that are experienced, by society generally. No anti-sexual harassment policy, and the reported consequences of this gap are that the few sexual harassment incidents, which the few courageous victims, because it's not easy to report that kind of thing for various reasons, those few cases that have been reported to the powers that be have not received the attention they deserve, because they are treated, if treated at all, as acts of misconduct in inquiries that take forever to finalize. I understand that there's no maternity policy as well, which some may raise eyebrows at judges pregnant, but judges do get pregnant. I was the first judge to fall pregnant on the bench, and the Department of Justice, which administered the judiciary then, simply did not know what to do with me. And as time to give birth came nearer, and I kept asking and asking what would happen with my leave, the late Mr. Labuskachne, who was our advocate, JB Skosana now then, and our big brother in the department, just said in frustration, Judge, I will just advise the minister to give you the 4 months, the 4 months leave allowed under the Basic Conditions of Employment Act, because I don't know what else we can do. But judicial officers are not civil servants, and they must have their own legal protections if we are serious about these issues. Let me start with the other one. The other issue, Chair, is the full capacitation of the Office of the Chief Justice. The whole notion of establishing that national department was, in addition to offering support, administrative support, to the Chief Justice and the institution, it was to create institutional independence for the judiciary, which now has its hands tied behind its back because it has no control over its own budget and expenditure. We've been walking this path, and JP Tlalitse and all judges have been walking this path for a while now. The issue of resources is critical. And it's a big problem, not just for the judiciary, but for the taxpayer too, because judges not having a say at all on the tools that are needed for the execution of their work, judicial work, not just work, impedes their performance and sometimes even results in wasteful expenditure. such as being provided with expensive laptops, which cost upwards of 34,000 rand, because they come with useless accessories we'll never use. We are not consulted when those things are procured for us. We are provided with leather-bound diaries. I got one recently and I was asking, who still uses a thick book diary in 2022? And other paraphernalia, about which, again, we are not consulted. And instead, Chair, sacrifices are made in respect of critical support and tools of trade, such as something as important as court assessors who assist judges in criminal proceedings, acting judges who help judges with case backlogs. Minister, I know your view on this, and I respect the rationale for the decision to do away with extrajudicial acting appointments, which is a critical, tool in creating skills transfer, among other benefits. In my court, at least, we end up sacrificing, Chair, subscriptions for law reports, books, legal books, law journals. I mean, things that are core to the execution of a judge's functions, core functions, research, legal research, and being able to produce reasoned, well-researched judgments. That's one of the consequences of this. Whew. So, Chair, yeah, I think I've said enough on that. If the OCJ is just given the power, the tools to just run its show, I'm sure we won't have these problems. Improving access to justice, which is a key challenge in this country. I'm happy to note that the Rules Board, with the assistance of the Justice Ministry, has done and is doing a lot of work to eliminate, for example, the outdated hurdles that would impede our people's access to courts, such as the oppressive jurisdictional boundaries and other requirements that impede our people's access to courts. And it is devising creative ways of bringing justice closer to our people in townships and villages. But because these measures are still in the pipeline, I won't talk to them. But I would just like to say something about the mechanism of mediation provided for in the new Uniform Rule 41A, which will assist greatly in unclogging court rolls and reduce litigation costs when used effectively. And I mention it because, as Minister will be aware, it still lacks the backing of primary legislation, which I understand is in the works though, and will allow, among other useful features, full court annexed mediation, which will be run by judges themselves. The SAJ, and this is exciting news, the SAJ is fully on board and will, with the help of a group of our judges who I believe they attended training on mediation in Utah in the USA last year and are busy compiling a syllabus for a rollout in the judiciary at large. So the SAJ, I'm told, will run a comprehensive training session for judges in June. They managed to sneak in the rules before the primary legislation, which is commendable, I must say, and work, forges steam, full steam ahead. So I hope, well, I have no doubt that the minister is actively attending the promulgation of the necessary litigation with all due haste. I understand that there's also collaboration with Nigeria, which already has an established system in place. While I still have your attention, Minister, there's another issue in respect of which we hope you can use your influence. I know you're not the Minister of Police, but you sit in the security cluster. The courts need assistance to achieve meaningful convictions in cases of rape. And we know the problems with getting DNA evidence. That gets lost, or the equipment used to, to process it is in a state of repair, and we hear that it takes forever to fix those, that equipment. And in the interim, the DNA samples, go stale or they become lost. We know that in the end, this is important. We have been reliably, it's a fact, that with DNA evidence, solid DNA evidence, 50%, as much as 50% of those cases, convictions will be achieved in respect of them. So if you can please whisper in the ear of your colleague and press him to do something in that area, we would appreciate it as South Africans. There is another issue, Chair, that will likely not enjoy any sympathy here as well in the country's palace financial status, but it is still important to mention. It's a very sore point for judges, and importantly, it may impinge on the independence of the judiciary and affect something you mentioned yesterday, affect the quality of judges we attract in the future, and maybe even cause some judges to leave the institution now. And that is the fact that judges have not received salary increases in 4 years. But that, of course, can be addressed elsewhere. I just mentioned it because of its importance. I will stop there for now, Chair, but in conclusion, I ask to briefly address 4 discrete points, briefly, that I believe need attention. The first one is a comment I've heard bandied around that it would not be a good idea to move me from the Supreme Court of Appeal because I've done so well there, and moving me would likely destabilize the court. I don't know if that's supposed to be a compliment, but I and many other colleagues find it most patronizing and even patriarchal maybe. To my mind, it implies that I lead a bunch of incompetents who would fall in a helpless heap if I left the SCA, and that bunch includes you, Chair. Nothing could be further from the truth. As I said earlier, the SCA is staffed with strong, capable judges, black and white, and as I previously stated, 8 most senior judges in that court are black. 5 women judges are already presiding. No shortage of skill and experience and leadership quality there. And let me highlight this. I will have spent 30 years at the SCA. I will have led it for 19 years if I stay there until my retirement. And I doubt that is healthy for the court and the people it serves. Now, the second point, Chair, relates to this idea of intellectual prowess versus administrative capabilities. First, they are not mutually exclusive skills. I myself am proof of that. During my tenure as leader of the SCA, I've been awarded, as I mentioned earlier, 3 honorary doctorates by 3 different universities, and I was installed as chancellor of a 4th one. Almost all the South African deans of law formally nominated me to be Chief Justice of South Africa. Despite a demanding schedule of juggling relentless administrative duties and my core function of sitting in court, my core function as a judge, I have managed to hand down upward of 200 reported judgments on a wide range of legal subjects, all which have been reported. During my very first stint in the Western Cape High Court in 1999, I broke a record of having 2 judgments reported consecutively in the South African Law Reports in the 2nd volume. I think it's in the 2nd volume of 2000. Only one judge, a senior permanent judge, had achieved that feat before. I think it was Judge Dion van Say. No one had 2 judgments in one, especially in the Green Books, in one volume. Now that trend, because of my industry, that trend continued throughout my High Court stint, despite working in a small division, Mthatha, and it got me noticed and invited to act at the SCA fairly early in my judicial career. Third point, Chair, is that if I'm appointed to the Constitutional Court, I would be coming in from the cold, and that might cause discord and resentment among the Constitutional Court justices. Chair, I enjoy good relationships based on mutual respect with each one of those justices. The entire 5 who came from the SCA were my juniors at the SCA, and I was their president, whom they supported and still do, and vice versa. I'm sorry, I don't like mentioning names, but I think I have to in this case. Justice Kolapen and I worked together very well, I must say, at the South African Law Reform Commission, which I chaired, and he was my deputy. Justice Madlanga and I, as he said yesterday, are old, we've known each other since we were youth. We are old colleagues. Notably, when he interviewed here for the Constitutional Court vacancy in 2013, he told this commission that he had been prepared to step back and not apply if I applied, because he thought I deserved to grace the bench of the Constitutional Court, to use his words. But the timing was not right for me, and I encouraged him to apply, which he did successfully. Now, Acting Chief Justice Zondo, one of the heads who supported gender diversity in the judiciary long before it became fashionable, he and I worked together at the labor courts in 2004 already, but unfortunately I could not stay long. He had wanted me to act at the LAC, and I said no, I was not familiar with the court. Let me start in the labor court and just to familiarize myself with the ropes. But then I got the call from the SCA before I could sit in the LAC, so I left. ACJ Zondo and I acted together at the Constitutional Court. We interviewed here together for a vacancy in 2012. We were both recommended for appointment. As I said earlier, he was chosen, I was not. I stayed on at the SCA and joined that court's leadership not long thereafter. Now, I say this without fear of contradiction, that ACJ Zondo and the rest of the Constitutional Court justices respect me, and they would support my leadership. I have no doubt about that. My fourth and last point, Chair, is that I believe that it's actually a huge advantage that I do not come from the current ranks of the Constitutional Court. What others describe as coming in from the cold, I see as bringing fresh perspectives and a wealth of experience from my time in the High Court, my long years at the SCA, and the almost 7 years in the institution's leadership, which has accorded me access to the other ranks of the judiciary and given me a holistic view of the entire institution and its challenges. It must always be also said that there is a long-standing lack of synergy between the Constitutional Court that sits up there and the rest of the judiciary. There is lack of synergy between the superior courts and the magistracy and the other courts. And we need a Chief Justice who is sensitive to these gaps and has the ability to bring cohesion and unity to the institution, so that all our courts can feed off and strengthen one another. So all 4 excuses, in my view, have no substance, Chair. I'll leave it at that for now. Thank you, Chair. I think I'm still within my 30 minutes.
I would rather not comment on that. Thank you, President Maya, for that presentation. At this juncture, I will also take a pause and allow the members of the Commission to put such questions to you as they might have.
Before we do that, Chair, could I just ask a quick comfort break? Just 5 minutes.
I wanted to do the same, Chair. After such a brilliant presentation, we must listen to ourselves briefly.
President Maya, your motion has been seconded.
Thank
so
you,
we'll take a comfort break for, should we make it 10 minutes?
10.
10 minutes. So we'll reconvene at 20 to 11.
Thank you, Chair.
President,
I think Commissioner Malema also.
Just give me a
just
moment.
on a hugely important point, it is tea time now.
Might as well take the.
So how long should we adjourn for?
The program says until 10 to
Until?
acting president. That's what the program says.
When is the scheduled tea break?
10:30 to 10:50.
Oh, good.
Yeah.
Yes.
Yeah, let's make it 15 minutes.
Until 1:45.
Yeah, thank you.
Thank you.
Fellow commissioners, in keeping with the traditions of the commission, will all those members who wish to speak alert me, and I'll make a note of them and give them the opportunity to put whatever questions they might have to the candidate in accordance with the order in which their names have been recorded. I confirm that I already have 3 names, Honorable Minister Lamula, JP Tlalitsi, and Commissioner Shabangu Mdawe. For the benefit of the recording team, I would ask each and every commissioner who wants to speak to press the mic, record your name, then I'll take it from there. Noted, Commissioner Madonsela.
Bofu.
Makwanisha.
Malema.
Okay.
Now, we don't know.
Making a note of the names, Commissioner.
We don't know if.
Please give me a moment.
Tepe,
No.
Commissioner.
Tepe,
Yes. Okay. Commissioner Mapisa. Commissioner Magwanisha.
yeah, I should.
I've already got him. Commissioner Moimang. Then
Oh, yes.
Commissioner Dodovu.
You spoke yesterday.
Commissioner Klama. Commissioner Lucas. Commissioner Singh. Commissioner Advocate Bofu, I've got you noted you. Advocate
Earlier,
Bofu.
yes. No, I'm raising something else. I know that you noted me earlier. I just wanted to.
No.
Oh, well, I want to
Okay,
raise a
let
point.
me
Yes.
first record the names of all the commissioners who want to speak, and then I'll give you an opportunity to say whatever you want to say.
Breitenbach, please, sir.
Professor Schlemmer. Was that Commissioner Breitenbach?
Yes, please, sir.
Thank you. Noted.
And Barnard, please, Acting President.
Noted, Commissioner Barnard. Commissioner Matolo Zlepo, I think I had your hand up a short while ago. No, unfortunately, you'll be number 17 on my list.
Do you have?
I hope that your questions will not have evaporated by then.
President, do you have my name? Yes.
Sepe, yes, I do.
Thank you, President.
Advocate Kane? Okay, sure. Noted. Commissioner Malema, I nearly overlooked you. You'll come in as number 18. I hope you don't mind.
I was number 3.
Okay, I think I've got everyone who indicated that they want to speak. Commissioner Mbofu, you indicated earlier on that you had something to say.
No, Chair, just wanted, maybe we can talk about it offline. I was going to suggest that we don't take names in this manner, because it just becomes a little bit undignified. Because if we're all going to be shouting and then we're not sure if you got the name and so on. I think we'll leave it in your hands, Chair. As the subject, sometimes you start that side, sometimes you start this side, sometimes you start with the people on the...
I started on this side yesterday, so
Yeah.
I thought that,
No,
today
yesterday
I
you
must start
started that side.
Right, yes.
So today you could start, and then another time start with the ones online. But we'll be in your hands. If we end up with being in the last, when we put our hands up first.
Well, the most important thing is that if you want to speak, then I record your name.
Yes.
Because ultimately, you'll have a
Thank
chance
you.
to
Thank
say
you.
whatever you want to say. Thank you, Commissioner Bofu. Honorable Minister.
Thank you, Acting President. It's difficult to say Acting President when the President is here. President Maya, good morning.
Morning, Minister.
Thank you. And I must say that I got a sense from your presentation that you are standing on your own, on your credentials, and not on the basis that you are a woman.
Thank you, Minister.
Is that impression correct? I thought you would want to say something.
Yeah, I agree with you, Minister.
Okay.
I'm not here simply because I'm a woman. I'm a judge, a worthy judge, I think, and I've proven myself over 22 years. And the fact that very important that I'm a woman, of course, but it's just one of the, I'm not good because I'm a woman. I'm just a good woman judge.
Thank you. I wanted you to say it. Thank you. The Constitutional Court in the certification judgment alluded to our kind of unique separation of powers.
Sorry, Minister. Chair.
Commissioner Malema?
How are we going to deal with the clapping of hands? Because it's unacceptable, it's wrong.
Yes,
Because
it,
if we
yes,
do-
it, yes, it is. In fact,
We run a risk of rent a crowd. That's where it will go.
yes,
If people clap hands in here, we
I
run a
take-
risk of people who are going to ask people to come here and clap hands.
yes, I
Must
take,
not be allowed.
I take your point, Commissioner Malema. You know, it's also something which doesn't bode well. We have to maintain the decorum of the, you know, and solemnity of the occasion. So I would ask the people who were responsible for that clapping to desist, and that they should just keep silent and observe the proceedings. Thank you.
Yeah, President, my first question relates to the Office of the Chief Justice in line with the separation of powers principle. The Office of the Chief Justice was an invasion which emerged from the interaction between the executive and the judiciary, and was always perceived as a transitional phase towards the ideal end state that suit the South African separation of powers. What lessons and features of the OCJ model do you believe must be considered in the final end policy?
I think, put simply, Minister, I think the OCJ, well, it's acquitted itself very well from its, you know, consecutive clean audits, done a really good job. And I think it should be maintained as is, save to just give it, I don't have the terminology, but we do know that not all the powers over the judiciary, which were traditionally exercised by the Ministry of Justice, were transferred to the OCJ. And that's what I was saying, that, you know, it must become a full national department now. All powers of a national department should be transferred to it so that it runs the show fully. And of course, it may need to be capacitated. For example, I'm clamoring for, you know, the bringing in of the magistracy and the other courts, and I don't know that it has the capacity to deal with that huge influx of human resources and the responsibilities that would come with that. So I would ask that simply, as it is, it's doing well, just capacitate it fully now.
Section 44 of the Superior Courts Act, maybe I should read it, I'm not sure if you have the act.
I do have a copy of the act, Minister. Let me just find it.
Gives the powers to the Chief Justice to determine the budget of the OCJ, and also after consultation with the heads of courts. And it then gives the OCJ the responsibility to account and all that. Is that not a solution to the issues that you are currently raising? Because, for example, I'm not sure, I will not really want to, we have not had a situation where there is that determination by the Chief Justice, despite certain instances where we want to engage on the matter.
Yeah.
I think you understand what I'm trying to say.
I would say yes, Minister.
So what is your observation in terms of what should be the relations that could happen between the executive and the judiciary as you become Chief Justice? Because there are those that believe that there's that interface that should happen, but obviously there could be amongst your colleagues that believe that there should be a Chinese wall or a Berlin Wall where there must be no discussion. Any kind of discussion is, it affects the independence of the judiciary.
There is one South Africa, one South African people, one flag, and all three arms of government are working towards serving that entity. So engagement is going to be necessary, you know, at various areas of you know, us trying to achieve serving the South African people. You know, just a practical example, I mentioned the engagement we had with the led by Chief Justice Mogoeng. I think it was in 2019, 2020, just before COVID, with the Justice Portfolio Committee. I had not had that exposure with the other arms of government, and I was just surprised with the level, you know, of mutual understanding and cooperation that arose from that, without in any way, you know, infringing on each other's, well, the independence of the judiciary, because that's always the tricky horse. We have to work together. There has to be an interface, as long as we ensure that, you know, in whatever endeavor we are pushing towards, we just carefully watch out for the boundaries.
Yeah, for your comfort, I agree with you. The second one is in relation to modernization, which you said you hope I will agree. Indeed, I agree. And it also falls within the same kind of category of line of engagement to make it a reality.
Yes.
Because we all want to see it being a reality. And if there is that engagement, I believe it is doable, it can be done. But my question is your involvement with the modernization and digitization project currently, because you do have, I know, as a pilot in Gauteng, but I know there's been some clips of kind of modernization even in the Supreme Court of Appeal. Yes. So what has been your role to move towards modernization, and what do you envisage it being as a Chief Justice going forward?
First, Minister, I was part of a delegation that was invited by a world leader in this area, China. Delegation led by CJ Mogoeng. It was CJ Mogoeng, JP Mlambo, who heads our JAID and IT committee, the judges, the judiciary's committee, and a couple of other senior judges and I, just to observe how it works. I mean, China is light years ahead of everyone in the world, I dare say. So that gave me an opportunity of actually seeing how far we can take this thing and exactly what it can do for the institution of the judiciary and enhancing access to justice. I mean, they even do cases by telephone in China. They have all sorts of creative ideas. They use, you know, they have a vast country, of course, but they're able to reach each corner of that huge continent and run an efficient judiciary. Well, that's one. So I have a fair idea of what court modernization, not a fair, I have a full idea of court modernization. I attended the BRICS together with the Chief Justice and JP Mlambo again. We went to Brazil, where there was a conference on this very issue, and you had the US, the UK, all these first world countries who again were shown to lag far behind China, that was speaking about blockchain and 5G back then, you know, concepts that the other countries were still trying to understand. So I know what it's all about and what the good it can do for us. And fortunately, and I know that you are a huge proponent of that, and I suppose the fact that you're a millennial, you know, gives you a natural aptitude towards tech. Some of us older, you know, we struggle with it. So I know that the judiciary has the necessary support to implement it fully, Minister. There may be constraints, budgetary constraints and all that, but we will get there. So I'm all in street parlance. I'm all in for it.
Yeah, no, thank you, President. Indeed, you have the full support of the executive on this project as the judiciary. And the executive is willing to help you to do it in a manner that you still believe will protect the independence of the judiciary. On the point that you have raised on the Section 29 of the Superior Courts Act, I don't want to bring you to judicial controversy, but and executive controversy, but you know why it is not being implemented.
Yes.
So how are you, and I know that you have said that there's not been a meeting of the heads of courts, and I will assume that you are raising this in your personal view. It is not a view that has already been canvassed with the heads of courts.
Not at all, not at all. I must make that declaration.
Yes.
Yeah.
Yeah, I wanted you to come with that you know where it is stuck, and ourselves, as the executive who are ready to implement the Section 29, if yourselves as the leaders of the judiciary says we should do so.
Then one would have to speak to the colleagues and make sure that the necessary happens.
Thank you. My last question relates to one last matter. You may decide not to answer it if you want not to, because I think as I answer the question, you'll begin to get where it comes from. It is the fact that as a Chief Justice, you are going to chair the small JSC that discipline your colleagues.
Yes.
And I've heard as we started the interviews with the judge, with acting Judge President Tsepe, you know each other very well for many years. Petse,
Yes.
yesterday he said he has known Justice Madlanga for over 40 years,
Yeah.
which I suspect is something that all of you know each other at that level as judges.
It's a small community, a very small community, Minister, and we all come,
Yes.
way back.
So how are you going to sit and be the chairperson of that day when you know each other and sometimes there are issues of conflict of interest, you have to recuse yourself. So how are you going to ensure that there is discipline and that judges who are supposed to go through that process are taken through the process, and you as a leader of the judiciary sit as you are supposed to sit when it's your colleagues, it's your friends, it's your, as you know each other as I can hear?
It should not be an insurmountable challenge, Minister. I'm a judge. Impartiality is the name of the game. DP Petse and I may have known each other for 40 years, but that does not mean we necessarily have a close relationship. There are relationships and there are relationships. And whenever, a matter involves a colleague with whom I enjoy, something extra, then I would simply have to recuse myself, and there will be an alternate, the Deputy Chief Justice, to step in that case. I don't have close relationships with all my colleagues.
Yeah, my worry is that you might have to recuse yourself in each and every time.
No. One thing, I am known to be a very warm person, but very firm. And when I become firm, people are usually surprised that is it the same person? So it's not a problem for me. Not all judges are my friends or close, close colleagues.
Yeah, thank you. Thank you, Judge, Acting Judge President Tsepe. Petse. I always say Tsepe. Petse.
And I do not mind.
Thank you, Honorable Minister. Advocate Kane has got a follow-up question, so I'll afford her the opportunity to put her
Acting
question.
President.
Thank you.
Good morning, President Meyer.
Morning, Commissioner.
I would just like to follow up on the Minister's question, because it's a very uncomfortable thing for colleagues to discipline one another. Yeah. And it requires a great deal of courage, and it's self-sacrificial in a way, because it's the last thing on earth one wishes to do. I need an assurance from you along the lines of the Minister's question that is really something you are prepared to lead in doing, And perhaps in answering my question, you could deal with the recent disciplinary matters that the small JSC has had to deal with, very, very difficult, quite traumatic matters, at least one of which you were not present in. Perhaps you could give us an explanation in that regard, please.
I imagine that you are speaking about the matter of Judge President Klope.
Yes.
You know, Judge President Klope is not even my friend. I was laughing to myself when I heard him explain, I think it was during his hearing before the tribunal, that the CJ and other colleagues had been invited to his wedding. I was not invited to that wedding. We don't have that kind of relationship. But we have a close relationship. I worked with him when I was quite young, fresh from the US. He was fresh from Cambridge. We were working together at the then University of Transkei. You know, these youngsters who had just come back to the country, were excited to do great things for the university. And we had that, and he was the head of my department. And then he went to Cape Town, and coincidentally, I happened to start my judicial career there. When Tsadeza SC identified me, the person he would have spoken to would have been JP Klope, who was the deputy judge president in that court at the time. And then DJP Klope would have spoken to JP Edwin King. So it's a very sentimental issue for me where I started this path. Cape Town, which was a very difficult court. I mean, we know about the challenges in that court, but it was extremely difficult even back then. There was an issue that concerned me and another, being long-winded now. But on the first week of our arrival there with the other black acting judge, there was a huge article in the Cape Times castigating our appointment to that court. So, and there was those dynamics always make for uncomfortable situations. And JP Klope was there to protect us and defend us. And we worked together. He is one of the judges. He and Judge Jeanette Traveso, one of my main mentors, helped me during a very, Cape Town is a big division, rigorous, rigorous division. And I was as nervous as anything. I mean, I started, my first case was a case dealing with ME, a full bench thing with 18, a huge record sitting in a full bench, and I was literally trembling. And JP Klope and Judge Traveso are the people who comforted me and reassured me that, hey, we're here to support you, you can do this. So I have that kind of relationship with him. And people know that I started my judicial career there. Imagine if I sat in a matter that involves him, and lo and behold, I write, I find in his favor. Even the threat of a perception, you know how it is. The judicial independence is a very delicate horse. So, even at the SCA, many cases came involving JP Klope, and all my colleagues, I made it clear to President Howie, to President Party, that look, I have a prior relationship with this chap. I would really be uncomfortable sitting in judgment of any of his matters. So I always avoided anything to do with him. But his is the only case that I avoided, if you want to put it that way. And I gave full reasons for that. I explained to the JSC ahead that, look, I can't sit in that one. I will send an alternate. The other one was the case of Judge Mutada. But I had not been able, I don't know, I just can't remember what the reason was that I was not able to come. And then Judge Nafsa, who was acting at the time, came. Was I on? I can't remember now. But Judge Nafsa came. But you will recall that at the tail end of those proceedings, I was there. I came. I did not recuse myself when I was able to avail myself. So it's only Judge Klope, and I know a lot has been made of that. Nothing sinister, Commissioner. It's just that I have that special. He's one of my. I look upon him as my big brother. Let's forget about the other business.
Thank you very much.
Thank you, Advocate Kane. Commissioner, you're covered.
Covered.
You're covered. Thank you. JP Tlaletsi.
Thank you, Acting President. And good morning, President Maya.
Morning, JP.
I know that you are well. Just one thing that I would want to clear up. I'm glad that in your response to the minister, you indicated that you stand here on your own mettle, your own credentials. And that brings me to the issue that the power to appoint the president of the SCA and the deputy, the Chief Justice and the Deputy Chief Justice vests with the president of the state president. He or she nominates and appoints. And it's for the first time that South Africans have been given an opportunity to play some role. Perhaps it will be defined later in this process. And what has happened before, I have known that we have always had good women judges with impeccable credentials who could have been appointed and who could still be appointed. It shouldn't appear as if it is actually a miracle. Now, this brings me to the next question, which was asked yesterday. Is South Africa ready for the appointment of a woman Chief Justice? I don't know if your answer is South Africa has always been ready. Perhaps there are those who who are vested with the powers may not have been ready.
You know, well, thank you so much for asking that question, JP. Look, I fully appreciate the sentiment behind it. I respect it. But I don't think it's a proper question to ask because it implies all sorts of negative things. But short answer is, South Africa has always been ready to have a female Chief Justice. At inception, as you point out, we had strong, capable women. In the Constitutional Court, we had Justice Mokgoro, we had Justice O'Regan, and we know them, what they're capable of. And in other courts as well. So there's never been a shortage of women who could take up leadership in any of the ranks of this institution of ours. Yes. And I'll tell you this, that question actually annoys a lot of women. And I've had people ask, was it ever asked if South Africa is ready for a black Chief Justice, and if not, why? Why are we asking about women as if we are this homogeneous, this special group that needs to be done a favor? Just you keep checking if they are ready, and then at some stage you think, oh, maybe now. No, that's not who women are. We're as capable as men. I need not say that. I need not say that, JP.
I think
women are able to do things well. Things have changed. Things have changed. Men can give birth now, so maybe I won't go that far.
I thought the star witness didn't understand that. Thank you on that. Yes. Something that I would want to clear up now that may have happened in the past, and I wouldn't want it to stay there as you go through this process. There was one issue that occupied the JSC in the previous interviews for the position of the Constitutional Court judge, and I know you had to recuse yourself. And on record, I do not think much was said about the reasons why you recused yourself, but there were some discussions between the candidate and the commissioners in your absence. And I think Justice Kachalia stood in for you.
Yes.
Yes. Now, maybe you could, if there's been any developments, clear it up. The reason why I'm asking this is that if you are appointed Chief Justice and you have a fellow colleague or judge who might feel that, and actually, I think she's going to be a candidate in the next round of interviews. She might feel somehow prejudiced and feel that I would not get it. And some may go further and say, since that time, she has not acted in the SCA is there something that's going on here? And whether you're going to recuse yourself there, up to when are you going to recuse yourself if that is the case?
Yeah.
Because two ways, either you'll be chairing if you are appointed, or you'll be representing the SCA if not appointed. Is there anything that perhaps we can clear up that?
I'm glad you raised that. You raised that, JP. Look, it's a difficult situation, and I don't want to say much about it for my own part. No secrecy about it. It's something that arose during, and I think the media was also there when this thing came up. Briefly, we are about to start interviewing for the Constitutional Court, and I find on my desk, and I see that other commissioners have been, furnished with this document, something from the JP, from the CJ, which was, I think, unfortunately, well, Mr. Chilwell can remind me, it was such a long time ago. But for the first time, we learned that the CJ was going to ask the candidate, I'm not going to name him, the Chief Justice was going to ask the candidate about an incident that had happened at the Constitutional Court involving hair clerks, out of the blue. And I was in distress because I immediately realized that I had to recuse myself. I could not possibly sit. And it was almost 9, we had to start. And I had to find an alternate. And I was, furiously calling colleagues, senior colleagues. And the most senior person, I think, was in Freiheit. Another one had a bereavement or something. I could not find some. And I went down our list until I found Justice Kachalia, who had his own commitments but graciously agreed to assist the commission. So he came in, and the commission knows fully, what had happened, how that came about. I had lost, from what the CJ and the DCJ had been said about me, I was compelled to file a complaint against that colleague. But as things progressed, I realized that actually if I followed through with it, it would bring the judiciary into disrepute, because we had a dispute that involved the 3 top judges in the country, and it came to a stage where it was the word of one against the others, and it was just ugly. So I just withdrew my complaint, and I decided to walk away from it. But unfortunately, my daughter was involved in this thing, and her view was that you are, meaning me, you're an established judge, you can afford to walk away from this thing because you are established, you've achieved all you want from your career. I'm at the beginning of my career, and there is this, stain against me now that I have to deal with. And so that's how this thing has stayed alive. And I may mention that it's a matter of public record. There is an appeal, actually, against a decision that was made by the JSC. I don't know at which stage it is. So that's what it is. Now, I've had to recuse myself each time the candidate has made herself available for a vacancy in that court, for obvious reasons. But I can tell you this, JP, we are all adults. Speaking for myself, I don't hold grudges. We are here, this is not about this job we have that comes with such immense power. It's not about us, it's about this country, here people. There is no time for personal issues. We fight with colleagues, judges are as human as everybody else. There are disagreements between colleagues all the time. But we make up, and because we realize that the goal is to achieve, to execute, that constitutional mandate in this book. So I don't foresee, I will not sit, I would comfortably sit in an interview that involves her and not hold anything against her, and actually vote in her favor if I believe that she has what it takes. And I would work with her anytime, anywhere, And I make that declaration here without any problem at all. Because, as I say, this work is not about personalities. It's about our country and the people. There is no time for squabbles, for personal squabbles. And I had said I'd be short, but that's, in a nutshell, is my answer.
Yes. Unfortunately, I got more than I bargained for. But
I'm sorry.
And the rule is never ask a question that you are not too sure about the answer. But then I think it's important that if needs be, that if there's still anything out of it that you provide leadership in your present capacity and in your future, should you be appointed.
Yes.
And then, yeah, something that I also asked yesterday, what's your view about the Chief Justice, the judiciary, vis-a-vis the media? Put it as the media, vis-a-vis the role of the Chief Justice, and then the judiciary, vis-a-vis the media, how to handle the media, how to deal with the media issues?
As I indicated, I watched some of yesterday's proceedings, and I did hear, fortunately, when that matter arose. And I want to throw back something very interesting you mentioned, with which I fully agree. JP, the OCJ, our department, has a communications department with a spokesperson. Now, you said something, the interesting bit is what you said, that we could have an office within our institution, perhaps manned by a retired judge. And I was thinking to myself that, look, first, the UK Supreme Court, for example, has a fully professional press office that deals with all issues that affect the court. Anything the media wants to know that has to do with the court, they deal with, and I believe they're professional journalists as well in that office, and communications specialists, and all sorts of fancy people. And which we seem to already have in the OCJ, as I mentioned. Now, with the addition of a judge who would perhaps deal now with the more sticky issues which require, legal information. I'm thinking of a case, for example, where there's something viral on social media that shows that the public misunderstood the import of a judgment. Mm-hmm. Now, the communications people may not be able to deal with that, and you don't want the heads of court and the Chief Justice do not necessarily have to deal with that. Now, if you have a retired judge sitting there, they would be able to just play an educative role and issue a statement, just dealing with that in a tactful way to make sure that, to address the misunderstanding and any other issue. I'm just thinking about something else now. We have a large cadre of retired judges who are in perfect health. And it makes me so jealous because these judges, they are working. They are working in the neighboring countries. They are doing arbitrations full steam ahead. They are working. And there is so much that they could do, but that's another issue now, I digress. They can do so much. You can employ them in all sorts of ways, including sitting in the JCC, for example, because I know that the colleagues who man the JCC and the JCT are uncomfortable about dealing with issues concerning their colleagues. But if you use a retired judge, for example, someone who's, there's distance now, then it becomes, and judges are very busy in any event. I know that my judges who sit in the JCC struggle because they have a very heavy workload and they must deal with these other matters and write judgments in these other matters. So yeah, in short, I'm sorry about going so far out. I would implement your idea by beefing out the communications office we already have, put a retired judge there to deal with all these things. Of course, that retired judge, if there ever was need, would consult the heads of court cluster for guidance and a mandate if something serious, arose that they felt they needed help with.
Unfortunately, my time is up. Thank you very much, President.
Can I
Thank
make
you,
a follow-up?
JP Tlaletsi.
I just want to make a follow-up.
Please do, Commissioner Malema.
Thank you, Deputy President. Thank you, President. Is it wrong for judges to recuse themselves from time to time when they think there could be a perceived, biasness or anything of that sort, where you feel as a judge, look, whether the facts are right or wrong, it doesn't matter, but for the sake of the image of the judiciary and for the perception, I will recuse myself. Is it wrong or is it the right thing to do? And does it help to enhance the image of the judicial?
That is actually part of the judge's code of conduct. You're expected to do that to avoid bringing any disrepute to the institution, because if just even a perception that you might be biased, is detrimental.
So it will be unfair to use two of your recusals, both on Judge Klope and on the matter we referred to earlier. It will be wrong to use that to want to create an impression of a permanent recuser, a person who just permanently recuses herself. Because I don't want to live here and then during the deliberation an impression is created that you're going to be recusing yourself all the time because you did this and that on 2 or 3 occasions.
2 occasions?
Yeah, on 2 occasions, on Klope and the one we're referring to. And now an impression wants to be created that you're going to be this absent Chief Justice who is going to be conflicted and not preside over critical matters.
No.
It will be unfair if anyone wants to use that argument where you did the right thing as a judge and recused yourself.
I couldn't put it any better, Commissioner Malema. I agree with you.
Thank you.
Thank you, Commissioner Malema.
Chairperson, I follow up.
Commissioner Matola Zlepo.
Thank you, Chairperson. Good morning, Justice Meyer.
Morning, Commissioner.
One of the things that I follow up on a question from our colleague here regarding the public's perception of judgments. Whether do we need somebody to explain? Because I'm not talking about political perceptions and everything, but I'm talking about how the public interpret judgments. Yeah. And you have found a lot of perception which is coming out wrongly to the public. Either maybe the media is part of that in interpreting the judgment. Don't you feel that somehow we need an office or communications office to try and interpret, in point form what this judgment means? I'll tell you why. I mean, the AfriForum judgment actually was very misinterpreted. And the public are left with that feeling that the Africans is being favored and everything. So I think you must look strictly into that. It's not for the benefit and the education of the public, not other issues. Okay.
I fully agree with you, Commissioner. In fact, this is something we often talk about. Look, judgments are full of legalese. They are sophisticated documents by and large. When an ordinary South African should be able to pick it up and read it and be able to understand it. And we've always felt that there just needs for something to be done to educate our people, not just about our judgments, even about the Constitution, their rights under the Constitution. The only thing we do, to reach out to the public when we deliver our judgments is this, what we call media summaries, which are just a tiny extract of the case. And that is certainly not enough. It seems to me that, I don't know which, maybe an organ of state or the judiciary, but someone has to take responsibility just to educate our people about the law, their rights, and the judgments that come out of the court. And it's just something, maybe that would be an agenda item, for example, in the judges' conference I'm pleading for. What role the judiciary itself could play in bringing about something of that nature. Sorry, a platform of that nature. I was just having a chat with a colleague of mine who's involved with the Rules Board, and she was telling me about moves that some of the things that the Rules Board is presently engaged in, such as setting up help desks in all magistrates' courts, in the townships, and looking at creative ways of, just transmitting information to people using a cell phone, which almost everybody in the world has. But it's something that needs to be looked into. It's important. It's important.
Just a follow-up. This side, Acting President.
Yes, you have been noted, Commissioner Klaver. You may proceed.
Thank you so much. Good morning,
Morning, Commissioner.
President. Thank you. I just want to make a follow-up, something I did yesterday. There is what is known as traditional approach that says judges speak through their judgments. And we also have a constitution that gives you a right to freedom of speech as an individual. Now, the question was, what is your take when a senior judge falls into temptation of entering into a policy discussion on matters in some cases would likely come before him or her at some point. What is your take? I'm raising this point because this is a senior position. You'll be the head of one of the arms of the state, and when you speak, the nation listens. What is your take when you now not follow this traditional approach and you claim that the Constitution grants you a right to freedom of speech, and therefore, a right to participate in any policy discussion? And thank you so much.
Thank you, Commissioner. I hope you won't mind the manner in which I'm going to answer the question. I'm on record before this commission, I think as recently as 2017, in an exchange with the Chief Justice, who was asking a related question about, judges' right, the right they enjoy along with the rest of society to freedom of expression. And I espouse the traditional view, which is considered as conservative, that judges speak through their judgments. Yes, we speak on public platforms. I do that all the time, but only for the discrete purpose. It would be scholarly platforms, and your presence there would be for the purpose of educating the public about the law and our institution and related matters. No more. That's my view. And I mean, most judges believe that it's dangerous for judges to put themselves out there. It's just, I mean, that's the honest truth.
Thank you so much.
It's not desirable.
Thank you so much, President.
Thank you, Commissioner Klaver.
Follow, President.
Oh, Commissioner Barnett.
Thank you.
Please proceed.
Thank you, President Meyer. Just on something
Oh,
you said.
sorry, he's online. I'm sorry, I'm looking for him. Good morning, good morning, Commissioner, sorry.
Good morning. Just on the statement that you made that judgments contain legalese. Now, if one thinks that the purpose of judgment is to give the litigants and its reasons for why the judgment has been made, do you think it's right that judgment should contain legalese? Is it not so that there should be a drive to write judgments in a way that they are understandable? In other words, not needing to have a press conference afterwards, for example, to explain and so on.
You're quite right, Commissioner. And you would know that one of the first lessons one learned at the SCA was that you write simply, simply and keep it crisp for many beneficial reasons. Simple and crisp. And I remember that one of my senior colleagues gifted me on my birthday with Fowler's use of English, which espouses exactly that. And that's why we discourage the use, even which is a sore point for some of us, the use of Latin, because our people are not going to understand what ex applicante cautela means, for example, and why do you want to use high-flown language in any event? So yeah, we have an obligation to keep our judgments simple, but it doesn't always happen. And actually, I had wanted to say, when I spoke about the Apex Court, that one of the things one would want to work on is just to keep the judgments short and shorter and simpler, But there's something we can deal with some other time. Yeah.
Thank you very much. Thank you. President.
Thank you, Commissioner Barnett.
Chair, may I ask a follow-up question, please?
Please do, Professor Ashley.
Thank you very much. Good morning, President Meyer. The discussion thus far concerning the legalese and making judgment simple and easy, how do you then see the role of the Apex Court, the SCA, in the development of the law, in the interpretation of the law? If your judgments are very crisp and short and not containing legalese, how are you going to work around the fact that quite a number of some of the recent SCA judgments that dealt with issues like prescription, for instance, missed the point and now created new precedent that is actually not beneficial to litigants, especially those that do not have money to take this on appeal to the Constitutional Court. We now have new precedents where people didn't understand the basic principles of prescription, it seems. So if your judgments are going to be, less complicated, less legalese, how should the lawyers of the future then be trained in understanding legal argument, using legal principles correctly? Would you mind helping me there, please?
You can produce a short and simple judgment with all the essentials in it, Professor Slema. I was very lucky. I started this in 2005 when there were giants in that court. And actually those giants were the proponents of that view that keep your judgments, especially if you're the Apex Court. And we were warned against, addressing, this thing of picking up all low-hanging fruits, addressing everything, and we criticize if you did that. That's how puny judges do it. If you can decide the case on just one point, do that. It is actually safe to do that, especially if you had not have, for example, a benefit of a good argument. Just decide on that discrete issue, and you can be sure that that issue will come back before this court again, and you can, deal with it at that stage. Short answer is, it is possible to produce a great judgment, which is short, but it still contains everything that needs to be said on the subject. as to the quality of the judgments, sorry, Commissioner, it's work in progress, and you're going to get these things, and we must just find ways of improving ourselves. And I'll tell you this, we started something at the SA a while back, but then, well, we didn't actually start it. Back in the days, we had, for example, Judge Louis Harams, a natural born teacher, who would, you know, occasionally give us peer training on IP law, which was his forte. And we picked up on that in later years when we realized that, I mean, we have judges, for example, brilliant judges who come from the magistracy and would have missed a whole lot of experience on commercial law. Well, I'm not putting myself in a better position. I missed out on that experience as well, coming from the bar. But that's another issue. Now, you have those kinds of people, industrious, intelligent people, but they don't have the basics. And a whole lot of us, because of our background, we missed out on on some of these experiences, unfortunately. So we decided to pick up on what Judge Harams was doing for us back then, and would have peer training sessions. I would invite even retired judges to come, just start with judgment writing, which Sajay does, but you can never have too much education, and I think having a group of senior judges, a few senior judges, you know, under one roof discussing something maybe even be more beneficial. So invite and have some of our most senior judges, judgment writing, shipping law, you know, all these subjects. I'm not quite sure what stopped us from doing that, because we had established a pattern, but it's something we're going to start again. And especially use our retired judges. So hopefully with those initiatives, we can give you and the rest of South Africa better judgments, Commissioner.
Thank you, Chair.
Thank you, Professor Slem. President Maya, would you please pull the mic closer to you when you respond to questions?
I'm so sorry.
Thank you. Commissioner Shabangu Mdawa.
Thank you. Sorry. Thank you, Acting President. Good morning, President Maya.
Morning, Commissioner.
I want to first declare my relationship with President Maya. She is the president of the Women Judges Organization. I'm the president of the Women Lawyers Organization, and we talk a lot regarding issues that affect women judges and women lawyers. Yeah. And secondly, Saula, my organization, supported her nomination, and the signature on that letter is my signature, Chairperson. That's what I just wanted to declare in this House. May I continue with my question, Chairperson?
Thank you, Commissioner. Yes, you may proceed.
Thank you. President, I want to touch on the transformation and empowerment of women. Doing that, can you please address the comment by the BLA where they are saying that under your presidency, in 2017, 5 of the 7 judges that acted at the SCA were white. 2018, 6 of the judges that acted at the SCA were white. 2019, 3 of the 8 judges that acted at the SCA were white. 2025 of the 7 judges that acted at the SCA were largely white males. I'm asking this question, President, because it will be very sad if this trend can continue if you are appointed as the Chief Justice. Can you please clarify on that?
Thank you for asking that, Commissioner, because I saw it, and is just a complete misunderstanding of what we're trying to achieve. I'm just going to mention just a tiny issue. At some stage, I wrote to Minister Lamola, asking if we could get 2 extra acting appointments over and above the SCA complement. Who would come and act at the SCA purely for transfer of skills? There is something, Commissioner, that we need to acknowledge. Black practitioners who become judges started on the back foot. And it is a fact that it is the white male judges who have the most experience in commercial law, these niche areas of the law. So the SCA, and let me just, in fact, a fact that I should have mentioned is what the Constitution enjoins this commission to look at when choosing judges, which is a judiciary that broadly represents, the demographics and blah of our society. So it is not a sin to appoint white judges, whether in an acting or permanent position. I want to make that clear. But I am a major proponent of transformation. If you look at who acts and who gets appointed, and this commission is my primary witnesses, who gets appointed at the end of the day, as I had pointed out in that letter I wrote to Minister, that I'm transforming this court. I'm getting junior people, junior women who need transfer of skills. So my aim is I will get 2 white males and my 2 women, black women judges. And we try, when we set our panels for sittings, we put these people together for the infusion of skills and experience. Now, I'm not going to say much more. All I'm going to point out to you, Commissioner, is look who gets appointed at the SCA ultimately. I pointed out here earlier that during my leadership, there have been 2 rounds of appointments, 5 vacancies during each round. Who was appointed during those interviews? So women, largely black, African males, and only 2, is it even 2? Only 2 white males. Women, especially black women, and males are appointed at the SCA. So I cannot be accused of being anti-transformational, not me. I refuse to accept that. But I'm not going to deny that I do invite these skilled white judges, but not exclusively, so that they can give us these skills that we don't have. I mean, I said in 2017 that I have no experience in shipping law, for example. I had said for the first time in a shipping law just before I came for that interview, and we had only 1 expert in shipping law at the time in the court, Justice Wallace, who we had to make sure during each sitting that he would be in that case. And it so happens with insolvency, insurance, and so on. You can't overlook that. We need the transfer of these skills and experience that white people have, had access to when we didn't. They have it, and we must get it. And the only way to get it is to get them to come and work with us and share these experiences. So I don't know if I've answered your question, but that's my attitude towards that issue.
Thank you, President Maya. You indeed answered my question. My second question, President, you alluded to the fact that judiciary does not have sexual harassment policy. It's surprising.
Shocking.
In this, we are living in a very, very a difficult time as women, where women are harassed, be it at school, at workplace, and everywhere, where judiciary does not have such policy. It's really shocking. President, when you are appointed as a Chief Justice, how soon can you make sure that this policy is in place?
Yesterday, Commissioner.
Thank you, President. My last question to you, access to justice. We always spoke about this. It's a concern between me and you and all other people who love this country. There are women somewhere in the rural areas, deep rural areas, where justice to them is taboo. They don't even know when are they going to access justice. When appointed as the Chief Justice, what programs or ways that you can put in place to make sure that those women out there access justice to the fullest, not bits, pieces, but to the fullest?
I happen to come from Bundus, Transkei Bundus, so I'm a village girl, so I know exactly what you're talking about. It's something that that needs creativity and careful thought, Commissioner. But I just like to keep my program of action, you know, simple, uncluttered, so that I can achieve. You know, when you have a big, you know, you have a whole lot of issues to deal with, you can easily get lost there. I thought, because if you recall, one of my my targets in my vision for the institution is to bring all the courts under the rubric of the OCJ, and I have this lofty idea of bringing in traditional courts as well. And I believe that through those traditional courts we'd be able to achieve something. But it's something that I would like to debate with other interested people and develop and see just how far we can go. But we need to bring traditional courts close.
Thank you, President, and thank you, Acting President.
Thank you, Commissioner. Commissioner Tsepe.
Thank you, Acting
Follow
President.
up.
It is a follow-up,
okay.
Minister, and I will be done. Good morning, President Maya. Thank you for engaging with us. I just wanted a follow-up on a question that Commissioner Ndawe raised about the issue you raised about the lack of policies relating to women issues, particularly sexual harassment and the maternity leave policy. Obviously, you say you want to deal with it as in yesterday. You are part of the leadership of the judiciary currently, and for me, that is such a key issue, and I would like to know that it is not something that waits for someone of your stature to even be appointed a Chief Justice, but it's something that could be implemented right now with your leadership. Is that something that is possible, I would imagine, and I just wanted your view and commitment.
You make a great point. Actually, through the Women Judges Association, we are already, we liaised, once I found out about this and we have stories of what is happening, you know, on the ground, and we don't want to get into that here. The South African chapter of the International Association of Women Judges immediately liaised with our mother body in Washington, D.C., because they have been working with the IBA and many other, you know, relevant stakeholders on these issues. And, you know, surprisingly, in many countries up north in our own continent, they already have established policies in place. One can go to town on those. So they have all the experience on that. So my chapter is already in the process of starting that process here, educating, and we will, once we get our ducks in a row, which should be very shortly, we will liaise with the SAJ, because that should be part of training, actually. When we talk about social context training, we also talk about these things. So we have, we've already kicked the can forward, but because we've not had, and you know how COVID has made things awkward, but we've not really had many heads of court meetings in the recent while. It is something I'm going to propose to my colleagues in that cluster. We'll package it. I know what I'll say to them. And of course, I'm not going to single-handedly implement a policy. I have to consult with my colleagues, and they have to give their concurrence and all that sort of thing.
Thank you, President Maya. Thank you, Acting President.
Thank you, Commissioner Tsepe. A short follow-up question, Honorable Minister.
No, thank you, Acting President. Judge President Maya, I want to put you more into shame that I know the former Chief Justice used to say that we are even beaten by politicians. We can't. So the ANC has a gender policy.
I know.
Yeah.
In fact, my association, when we host our, even our AGMs, our conferences, we rely on your largesse, Minister. I've made entreaties to you many times for help, because we have nowhere else to get it.
Yeah, so I want to ask you on this one that you are raising of the appointment additional to the establishment. That I confirm that you did write to me, and indeed we could not agree, because you are not the only head of court who wrote to us requesting to continue with the same practice, which affect the National Revenue Fund, and it has got budget implications, which National Treasury has raised with us. I just want to state that will it not be possible to do this transformation that you spoke about within the establishment that you have, because the current financial situation of the country is precarious. We have written to all heads of courts on this issue, because if we allow the Supreme Court of Appeal, we must allow everyone.
Yes.
And the costs are enormous.
No, you're quite right, Minister. We understood where you came from. I agree. We have to be creative and work with the resources we have within ourselves.
Thank you, Acting President.
Thank you, Honorable Minister. Advocate TG Madonsela.
Thank you, President and Chair. Good afternoon, President Maya.
Afternoon, Council. Oh, Commissioner, sorry.
Yes, you've been the president of the SCA now from 2017 as the head of that court. And you are now applying, or rather making yourself available for appointment as the Chief Justice of the country. In other words, you will be the head of the Constitutional Court and the judiciary as a whole. I would like to ask you a question that has to do with access to justice, ultimately. But I go to that point via other ways. And I want to ask a question concerning the coherence of jurisprudence that comes out from our courts, right from the SCA to the Constitutional Court. On the rare occasions that I've had the moment to read some of the judgments from the Supreme Court of Appeal as well as the Constitutional Court, it appears to me, and please correct me if I'm wrong, that there are too many instances in which the SCA is upset by the Constitutional Firstly, is that correct? If that is not correct, or if it is correct, is it not important for both courts that we have a coherence of jurisprudence coming from the SCA affirmed by the Constitutional Court? In other words, shouldn't the SCA get it right as an appeal court rather than it being too often upset by the Constitutional Court? And what will that have? I ask this because of the importance of the certainty about the law, because it ultimately impacts on access to justice, because if litigants do come to lawyers for advice, they would know readily what the law is, because it has already been firmly established either by the SCA or the Constitutional Court. So what is your comment on that? Do you think that there is some disparity, or there is a trajectory in which the SCA is too often upset by the Constitutional Court? And is that the right thing? Is it a good thing or bad thing?
Thank you, Commissioner. The first principle is that the law must be certain, so there has to be coherence. But, and please make sure that you put this question to ACJ Zondo on Friday. A colleague has told me that as many as 95% of the applications for leave to appeal from the SCA that go to the Constitutional Court are thrown out. So the tiny percentage you speak, you know, your question arises from only a fraction of the cases that actually do get set down for hearing there. But of course, even those matters, they are important matters. The very fact that they get set down, and if a majority of them, even if they're just a tiny proportion that come from that come from our court, then we must do something. But your question actually is not far apart from what Professor Slever put to me. We're trying, Commissioner. We're trying to get it right.
Thanks. As a leader of the Supreme Court of Appeal, you have a court that sits in blocks. And in the Constitutional Court, you'll sit as a block, a full court,
yeah,
not panels of judges. It seems to me that it is at the SCA level, you would have had to allocate cases to various panels of judges.
Mm-hmm.
In allocating cases, you would be identifying cases which are important, or you regard as the SCA as important, and allocate to a particular panel. But you will not have that choice in the Constitutional Court. Now, I want to find out if in the SCA, have you been able to tackle as a head, as a leader of that court, cases which you regard as important for the judiciary to stamp its judicial authority on a particular topic?
Sorry, you mean me as a presider?
Yes. And if you have, which of those cases do you think come to your mind readily?
Yeah, I've heard that I don't sit in important cases, and I'm not even sure what that means, Commissioner.
I didn't want to ask the question in that way, because
yeah, I appreciate it.
I didn't think that it had any merits, but
no. AfriForum, the control, because it looks like people judge cases by their controversy. I presided in a matter that involved President Zuma not so long ago, where he had been ordered to pay costs on a personal basis. I presided in that case. I may not have written the judgment, but I led that case. Okay, let me not dig myself into a hole, because I was going to say I've sat in cases that involve political parties, but let me not do that. But I've sat in important cases. I've sat in customary law cases. a neglected area of our law, which happens to service a huge component of my people, your people, our people. And I've written judgments there. Sand Fleet, I've written a few cases on customer. I mean, I wrote on the right to bury on a farm owner's land. I think that's a critical case. I've written in rape cases. Look, all cases that come before our courts are important. South Africa being a rape capital of the world, I consider rape cases to be some, if not the most important of the cases that come before our courts, because through our judgments there, we tell society that this is unacceptable, it will not be done. And I've sat in many of those matters, Commissioner. I sat in F and developed, I hopefully developed, I wrote it, my first substantive dissent there, and went against senior colleagues, which was an intimidating.
And F had to do with the
vicarious liability of immediate
cause and scope of employment.
Yes.
Yes.
I've written on a wide range of cases. I may not have sat in many politically controversial cases, but I've sat in important matters that required, senior colleagues to determine them. There are many of them. I think I have a list of my judgments somewhere that
Yes.
lists. I've sat, by the way, I've sat in close to 600 cases just at the SCA. And you can imagine the wide scope that covers. So, yeah.
President, thank you for that.
Thank you, Mr. Matonzela.
Thank you, Commissioner Matonzela. Commissioner Nyambi.
Thank you, Acting President. Afternoon, President.
Afternoon, Commissioner.
I must also indicate that as somebody coming from the province where when the sun rises, the people works harder, called Mpumalanga, I attended the inauguration of President Maya as a Chancellor. And the Premier of that province, Honorable Mtsweni Tsipane, and the Vice Chancellor, Professor Mayegis, and the Minister of Education in South Africa, and the Chair of the Council, Professor Babunda, all of them quoted your friends that are saying you are a person with a serious, sharp legal mind and a fine grasp of the law across broad spectrum. I must indicate that as somebody that has been here for some time, the stories of SCA as told by people that came here to be candidates to be interviewed, I was only assisted when we interviewed the last people to be appointed at the Constitutional Court, especially Justice Matopo. And he credited you for having dealt decisively with the division of that court as you try to explain it. And we've got some serious challenges in a number of divisions. Probably if you can take us through the day you set your foot in that office for the first time as the leader and the challenges that were there and how we're able to deal with it without us just assuming that you dealt with these things. So I want to have a sense of how you dealt with those challenges. Because we've heard those many stories, but when we interviewed Justice Matopo, who's now at the Constitutional Court, he was able to assist us to have a sense. But now we're fortunate we're interviewing the very same person who dealt with the challenges. Take us through that first day and how we were able to deal with those challenges.
I suppose the question is, how did I turn the essay around? All right.
Exactly.
Thank you, Commissioner. Look, I cannot take all the credit for the positive changes that have taken place in that court. Despite all the wrangling and scratching among colleagues, which resulted in the unhappy situation that the Commission knows about, at any stage of my tenure in that court, there always was the judges, and this is apparent from the fact that that court has always been one, if not the most efficient in the country. So people always worked very hard. It was just a few things that made the situation untenable for some of the colleagues. So my colleague, all the colleagues I've worked with, always cared deeply for the court's welfare and their work. It just needed, they say it takes one person to start a revolution. It just needed one person, Commissioner Nyambi, to stand up and say, the emperor is naked. This is what is going on. And once that was done, people were shaken. I remember after the interview where I made the revelation here, I was thinking, my goodness, there's going to be a big fallout when I go back at the beginning of term. But we managed that. But what I'm saying is, once the challenge was laid bare, and I made the effort to, remember when I mentioned that to the Commission, I said we had already started a process, but it was early days and it was difficult, of what do they call it, this training in cognitive bias and inclusivity training, it's social context training in simple terms. We'd already started that. So I managed to prevail on colleagues, with the help of colleagues such as DP Petse and many others in the court, to turn the situation around. I guess the short, simple answer, Commissioner Nyambi, is that, as we all know, communication, speaking frankly about things, is the one thing that will repair any relationship, even a marriage, even a love affair. So being able to talk our problems through, agree, but the difficult thing was to get everybody to agree to undergo therapy, because that's what we did. That was the toughest bit. But we managed it, because colleagues now suddenly realize that we actually have a problem, and it looks like we might be able to fix it. So it is through, I'm the one who was a whistleblower, but with the goodwill of my colleagues, we managed to turn the situation around. And maybe I should just take this opportunity to thank my colleagues for their cooperation and willingness to listen to me and help me in what I was trying to do for all of us. So I thank them for their grace for that. And that's my answer.
Thank you, President Maya. My last question, in your view, what is the most efficient, proper way of constructive engagement of the arm of the state as somebody aspiring to lead one of the arm of the state, which is the judiciary?
I'm not entirely sure I understand the question, but I take it it's not dissimilar to what I think it was Minister and another colleague about engagement with the other. It was the Minister, I think. I intend for the judiciary to have a relationship with the other arms of government to the extent that the Constitution expects us to. And as I said to the Minister, there has to be an interface. We have to engage. I mean, we're all working towards one goal, and it will one endeavor of ours will need the assistance of another arm of government to achieve. So we can't work in silos, if I can put it like that, Commissioner. We have, as long, let me stress this, the independence of the judiciary and the exclusive terrain of the other arms of government is not disturbed, we can cooperate.
Thank you, President Maya. We are fortunate as Mpumalanga to have you as somebody leading that beautiful university.
It is beautiful, Commissioner.
Thank you, Acting President.
Thank you, Commissioner Nyambi. How I wish all the other commissioners who are going to speak after you would emulate your good example and be short and to the point. We'll see from Commissioner JSC who's the next.
Thank you, Acting President. Good afternoon, Chief Justice Maya.
Good afternoon, Commissioner.
Okay, thank you. I just want to first remark on this because I just want to focus on the leadership issue that has been. In 1986, you could not do your 5th year in BPROC because of the unrest at the university.
Yes.
And you were part of the students that also experienced the brutal murder of Bathandwa Ndondo. It happens during your time.
Yeah.
I want you to reflect on that, how it impacted in your perception, in your ideology as a person about South Africa and the path that we have to go through. How that impacted your life as a person.
Commissioner, I don't find anything extraordinary about that experience first, because it's the experience of all Black South Africans who were alive at that, during that eon. It's, how can I put it? The scars, because that was traumatic. Bathandwa Ndondo was my classmate. I said he was my deskmate in our statutory interpretation class. So you can imagine how I felt when that happened. And almost all of us have had, if not all of us, had our own traumatizing experiences. But I think those experiences have actually given us the ability to be able to implement the values that are espoused in this Constitution, because we know precisely how this Constitution came about when it speaks about human dignity, when it speaks about equality and all the other things, the Bill of Rights that it provides for. It seeks to heal the wounds we suffered and develop a new country, a normal country, for our children and the next generations. So I think experiences like those just serve to add depth to what we already have: ubuntu, compassion, empathy, and all these good qualities that are needed. I'll speak about this context in a judicial officer. So when a poor person, a person from a disadvantaged background appears in my court, I know where exactly they come from. I bring that insight into my judging. And I don't know if I can put it any higher than that.
Yeah, and your work as a clerk. You started it's a humble beginning as a clerk, and shortly thereafter, later you are involved as a founding member in the International
Association of
Women of Jurists,
Women
where you
Judges.
become president. Your activism in BLA and NADEL. Like, I'm bringing this because of the remark that the BLA in the document that you would, with such background, you would be part of overlooking of black candidates, or of not at any stage of being a person who can abandon the agenda of transformation. I want you to reflect on that and the background of yourself with this that I've just read.
Yeah, as I say when the question was raised earlier, Commissioner, the BLA completely misunderstands. And I need not say more than what I alluded to earlier, that this commission is my primary witness. Because you know, when we interview candidates for the SCA, what I say here, you know. And the statistics, SCA statistics speak for themselves.
Yeah.
Need I say more? I don't think so.
Yeah. Now, moving away from that quickly, the GCB reflects on the court cases you mentioned. You said more than, they say 640. They write about 640.
Yeah.
And they are benevolent enough to confirm that in most of your judgment, your colleagues have agreed with you. There are many of unanimous judgment that you have written. To me, that talks to collegiality. To me, that talks to your leadership, within the judiciary.
Thank you, Commissioner.
Yeah. So this issue of, I've been reading CASA comments, which I agree with the comments, with the criteria they set, as well as the university, the democratic unit of the university. But there's this tendency of saying, we must ask you to tell us that you are an intellectual. Is it right? Is it not us, in terms of the judgments that you have written, us who must say this is an intellectual, this is a jurist, this is an intellectual lead? But it can, I've not seen except the biggest arrogance if one goes around and say, I'm an intellectual, I'm this person. How does that come? Because your judgments, in fact, I just want to summarize, your judgments, we are involved more than 640 matters, many unanimous decisions. The court you have read, you are presiding is reported here. This, I would like to read what they say. The Supreme Court of Appeal in the 2020-2021 year of assessment exceeded its performance target of finalizing 80% of its matters timelessly. It also timelessly finalized 99%. So the court, in terms of that you are leading, is a testimony. The judgments that you have done support. And lastly, so that this is my last question. This is a matter you have alluded to. I've looked onto the Constitutional Court current judges. I think there are only 2 judges in recent years that were not at the SCA when you became the president. That is Judge Zondo and Judge Madlanga.
Yes.
All of them, they were there when you were their president.
I was their president.
And it goes back, even when you were the deputy acting judge president, way back in 2016, is it 2016?
From 2015.
2015. These judges are there, you have worked with them, they have supported, they regarded you as a leader. Is it not really one of those attempts by some people from corners to undermine leaders, particularly women, to simply say, no, this person is just coming from outside? How can you be coming outside to people that you actually led over so many years, since 2015? That was my last question for your comments, General.
Well, those justices, and I can say this, they can be asked, they don't consider me an outsider. And as I said earlier, and I speak this with absolute certainty, they would accept my leadership without doubt. They support my sitting here now. So, maybe let me take a quick chance. You mentioned something about statistics that say it's an internal thing, but I know that my colleagues feel very strongly about it. That achieving that target, that we achieved the target of 80%, the SCA, we've had a fight with the OCJ. We dispute the accuracy of their measuring tool of our performance. The FCA's performance has to be in the high 90s. We have really, but that's something else. I just had, because that 80% judges, my colleagues are not happy with. Just that, Commissioner, thank you.
I must thank you, President, and I must confirm as I take my seat back that from the document, from the leadership, the school up to now, it would be unfair for anybody to suggest that you would be considered just because you're a woman.
Yeah.
There are many men who in 1986 would even fear to hold a stone. So it's worse to be fired at the university. What is their leadership then if you are not the person? Thank you very much.
Thank you, Commissioner.
Thank you, Commissioner Nokesi, for your brevity. Commissioner Tsepe.
Thank you, President. Acting President. Good afternoon again, President Maya.
Afternoon, Commissioner.
President Maya, there are just two issues I want to deal with you. They are, in fact, a bit of follow-ups. One related to the modernization project that you spoke about. And I just wanted to find out from you, because I think modernization as a project for the judiciary has been a great project and which helps with access to justice. So the first issue on that, I wanted to find out from you, having implemented it as a pilot in the SCA, are there any challenges that you have found as the leader of the Supreme Court of Appeal? And if so, what are they and how can they be resolved? But the second issue, while you answer that one, is the issue that Justice Madlanga raised about modernization and online, online access to courts in relation to other communities who do not have access, and what other ways can we introduce into this modernization, particularly online access, so that other members, vulnerable members of society, would be able to have that access, because we have seen how important it is in accessing justice for others who are able to do so. That's my first question.
Thank you, Commissioner. About modernization, look, there have been challenges. We still experience challenges. In fact, even now, for example, just about connectivity, which is something that we hope will be looked into. The fourth term, I was on leave, but I understand from my colleagues that it was rough. There were struggles, but we managed. So we have to look at those niggling aspects. We asked for case lines to be implemented because we saw what a success Gauteng has made, has made of it, and we were always envious because our acting judges from Gauteng they were demanding, their records while we were struggling with piles of paper. They were using case lines, so that's another aspect that encouraged us to get on the bandwagon. But we said, all right, let's just give it a shot. Just start with petitions, the applications for leave to appeal, and then when it is established, we move on to appeals proper, and we just use it completely. But we have not got there. And look, judges are largely elderly people. Some of us still struggle with technology. I have to confess, I myself do not use case lines all the time. I still love the feel of paper between my fingers and flipping over, you know. And that's, I suppose it's the same for many of my colleagues, but many of us use it. I use it sometimes. And it's something I'm going to push actually when we go back now, that we move on to appeals. But there had been a problem about finances or something like that, but I think we can get past it. We have Gauteng, our Lodestar, will use whatever means they've used to ensure that we also get on the bandwagon. So the challenge really has been connectivity, which is something that can easily be fixed. About online courts, we know that a huge majority of our people do not have access to the internet. You accept that. As I said earlier, some of these things are still in the pipeline, but Minister will protect me because he knows about them. I understand that there is a move to have big screens in where our people live, in the townships and villages. And I imagine that those facilities, that they would be put in magistrates' courts. I imagine that where there's no court, they would use community halls, even churches or schools. So the reality is that we can't go back now. We've been introduced to this reality, and we have seen its benefits. Of course, I envisage that we'll end up, when COVID is tamed, we'll end up with a hybrid system, because there are still proceedings that need, you know, in-person interaction. But for civil matters, it cuts the access to justice, a point you mentioned, the expense. It just cuts out a lot of expense, and it actually benefits those very people in outlying areas to use it. So we just have to be creative about it, and we'll have to make it. We'll take this virtual reality to our people. It is possible. That's what I see into the future. And as I say, the rules board, there are moves afoot to do some of that. I don't know if I've answered everything.
You have, President, and thank you very much. My last question relates to the work you have done at the SCA that you have alluded to, and the JSC would know about recruiting of women, particularly black women, to that court. And in your article, Judicial and Legal Response to Gender-Based Violence, you said something that I thought was quite profound, which was that the fate of these victims, and in my case, I would say women judges, should not be left to the off chance. So meaning we have to have systems in place and formalize them to ensure that the work that you have started at the SCA continues. But as a head of the judiciary, that work would need to be formalized. And I just wanted to know, what systems would those be that you put in place to ensure that we actually, as you rightly said, that the work of transforming the judiciary along gender lines has not been completed, and it's a task that should happen throughout. But I just want to know, practically, how do we do that, and what is your proposal in that regard, or how you would be implementing that? Thank you,
thank you, Commissioner.
President.
Thank you. Well, first, it cannot be my sole project. It's something I would have to have the buy-in of my colleagues in the heads of court cluster. And fortunately, the heads of court are very sensitive to the need of diversifying. I'm getting tired now. Diversifying the institution in terms of gender. And in fact, as you know, we have we're counting now the DJPs, the women DJPs in some of the high courts, and one fervently hopes that these numbers will grow, and we will make them grow. So we have to have a formal policy as heads of court, because those are the people who invite people to act, who come here with their candidates and recommend who the JSC, in the final analysis, should recommend would be suitable. So I think there needs to be an agreement that if you have an acting vacancy, for example, and there is a woman available, they're just small things. There's a woman out there, and there are always women available out there. Give a chance to a woman. If you have 2 acting vacancies, make sure that one of them at least is a woman. But I'm sure those are things we can agree. Those are things some, if not all of them, are already doing. I mentioned this aspirant women judges project that the SAJ has resuscitated now, that starts in July. I mean, that's going to create a pool. I'm sorry, I forget, because I had asked how many candidates it has, but it's quite a number of women. We're not going to have a shortage of women candidates from which to appoint. And once those people are already in the system, then it's a simple matter to get them. Once they get enough experience, you push them up. Fortunately, the heads of court cluster is a small body of very collegial judges, and the heart of everybody is in the right place. So we know what we need to do, but it just needs to be pushed harder. Some may not be pushing as hard as I am because I'm a woman. I know my answer is all over the place, Commissioner, but
it's not, President. I think for me, the issue that you raised of formal policies, because it should not be about the people who are there whose heart is in the right place. When they leave with their good hearts, someone else who come may not have that heart, that we should have these policies and processes in place to ensure that that project moves on. Thank you so much, President.
Thank you,
I appreciate
Commissioner.
it. Thank you, Acting President.
Thank you, Commissioner Zepe. Commissioner Mapisa Ngakula.
Thank you very much, Acting President, and thank you, Judge Maya. Thank you very much for the vision which you shared with us this morning, which was quite informative, and I should say, demonstrated highest levels of leadership on your side. And therefore, it should have been easy for everyone who was listening to your vision to understand indeed what your vision for the judiciary is. I may have missed 1 or 2 issues when I stepped out, and if they have been raised, please do not, I can always consult with my colleagues. One of the matters you raised was the lack of synergy between what is happening at the level of the Constitutional Court and other courts. And my question is, how will you ensure that there is that synergy? And I'm raising this fully cognizant of something which you raised earlier, which is that the last time you had a meeting, for instance, as the entire community of the judiciary was in 2019.
2009.
2009?
Yeah.
2009, not 2019.
No.
If I may raise the matter, how will you rectify this anomaly? How will you ensure that as a judiciary in the country, you move in unison? That even if you are at different levels, but there's an appreciation of the different roles, but also an appreciation of what you have raised here, which is that whatever it is about the country. We serve the country. That's the first question. Thank you.
Or should I answer that? Then you'll carry on. Oh, thank you so much, Commissioner. What I meant about lack of synergy first is that the Constitutional Court has always existed in that bubble. You know, it's that court up there to which most even the judicial officers don't have access. And I have just one short practical example of what I see in my mind is this conference where you would have all judicial officers starting from the top court to the small claims court under one room, because it is only through communication and debates and sharing of ideas by everybody. I mean, each court has its own challenges and needs and experiences. Imagine if you bring all those into one melting pot and people brainstorm about things, the product that would come out of that's simple solution, just one solution that I have in mind. Bring everybody together. Just break down this, the judiciary, I'm sorry to say this, it's like the army. Ranking is everything, seniority is everything. And I'm embarrassed sometimes, even high court judges who are acting, they will not call me by my name. And I mean, it's a common practice, yet we are colleagues. So we have, these are some of the things that we have to just debunk, these old relics. When magistrates, you know, when a magistrate was walking down the passage, you had to quickly move aside. Understand that we are all judicial officers who are working towards one goal of, you know, giving this service to South Africans. And I'm sure there's a lot I can learn from a commissioner in the small claims court, for example. And with that, you know, what do they call it? What the bees do? Cross-pollination of experiences in the different courts. We can come up with something astounding for our institution, Commissioner, I think. So, look, there's a lot I could say, but at a basic level, that's just what I have in mind. Just break down the barriers first between the different levels of the institution. Bring everybody together to understand that we are working towards the same goal, and maybe a justice. They may be a commissioner in a lowly court, but we are actually doing the same thing. And we need to work together to find solutions for a global institution, not just for that court there, but for an institution.
Thank you, Judge Meyer. Then my second and last question. Yesterday we raised issues here which are topical. 3 of those relate to the quality of judgments, the time it takes to finalize cases by the Constitutional Court, which is a matter you addressed earlier on, and how you have done it in the SCA. Yes. And then the combative language sometimes which is used in the judgments. Now, I'm not trying to, but these are topical issues. These are issues which everybody is talking about. Now, if you were to be appointed and you move into that environment, of course, we we've heard earlier on that you seem to have very close relationships with people who are already your colleagues in the Constitutional Court. You seem to be relating across the board with everybody. How will you then ensure that some of the things which you've effected at the SCA are done in a, I don't know the term which one would use in this case, if I'm saying, if we are talking about the quality, but also the combative nature of the judgments. How will you, I won't say improve, but how will you ensure that South Africans do not feel there isn't this kind of perception about this in the Constitutional Court?
Thanks for that question, Commissioner. Look, my experience is that in a cohesive, unified, collegial environment, you will not get that. The issue of combative language, I mean, it used to be an issue in our court. And I mean, there are simple ways of dealing with these things. If a colleague writes something that is not palatable, you speak to them and you tell them, you tell them that I refuse to put I agree with the essence of your judgment, but I will not put my signature to something that speaks in that kind of language. I will write, I've even threatened to write a concurrence, a one-sentence concurrence that says I agree with my learned friend, but not the tone of their judgment. But on a serious note, Commissioner, if the court is if there's firm leadership, there's cohesion, and that's those are some of the qualities I said are required in this office. Someone who's going to bring that. If you have that environment, then it's easy to solve these things. Yeah.
Thank you very much, Judge Meyer, and thank you, Acting President.
Thank you, Commissioner Mapisa Makula. There is a follow-up question from JP Tlaletsi.
Thank you, Acting President, and thank you, President Meyer. I think I need to also raise an issue regarding the Judges' Conference, that we obviously have been given a reason why we could not have one, which has been financial constraints to get all the judges together under one roof, or the judiciary. So I think the chairperson of the portfolio committee and the minister being here will kindly commit themselves to assist the judiciary in having this conference. Because once we leave it open like this again, it's going to be something that will keep on recurring, that there are queries, we do not have funds, we cannot. I mean, these are the issues also that the judges have been raising, that could we have one, but the issue has been financial constraints.
Yes.
Thank you.
No, thank you, my I almost said my brother. Thank you, Commissioner. Look, I fully support the plea for assistance, but look, I have to disagree with the financial constraints was an issue, but judges were actually prepared to pay from their own pockets to attend that conference. But I don't want us to get into that.
Thank you, JP Tlaletsi. Commissioner Magwanishe.
Thank you very much, Acting President. Good afternoon, President Meyer.
Afternoon, Commissioner.
Maybe before the chair. Chair, I didn't understand what the JP was doing with that input. I didn't understand whether he's disagreeing or asking a question or what, because we're going to have our turn to make our own observation. So I don't understand where do you put that, because if you allow that, then we're going to have to do it with other candidates. The JP made a follow-up, but I didn't understand what did he want from her. Was it a comment? Was it some clarifying her factually or what? I don't know.
I'll give JP Tlaleza an opportunity to respond to your query. Just briefly, otherwise, we shouldn't allow ourselves to be sidetracked. Thank you, Commissioner Malema.
Thank you, Acting President. The purpose of raising this issue was to place it on record that regarding the conference, it has been an issue that has been discussed, and this has been the explanation that was given. And that's why the President agreed with me, but she's had an additional view as to why it was not held. And I was also pleading to the relevant stakeholders who have the financial muscle to assist to do so if possible. Thank you.
Thank you, JP Tlaleza. Commissioner.
Well, I will take it up when we meet. Perhaps I will ask that when we adjourn, you allow us a brief moment to remain as commissioners, because I still don't understand. I want to take up an issue with that.
I propose that we leave it at that, Commissioner Malema, if you don't mind. Commissioner Singh,
yes,
do
thank you.
you
Just
have anything to say?
A very brief follow-up on this conference. I just want to know why a virtual conference cannot be held.
Please pose your question to the candidate.
Or should I pose it to, I mean, is it not possible for a virtual conference to be held if financial resources seems to be the constraint?
Eminently so, Commissioner.
Thank you, Commissioner Singh. Commissioner Magwanishe, I'm sorry for the interruption.
Thank you very much,
Thank
Acting
you.
President. Good afternoon, President Maya.
Afternoon, Commissioner.
It's good to see you on the other side.
It's painful for me, Commissioner.
Initially, I had 40 questions for you, but with your vision and your answers, I've reduced them to 4.
Still
4. The first one, when you were interviewed for the position of President of the Supreme Court of Appeal, you spoke passionately about the role of academics as judicial officers. What is going to be your program concretely to ensure that that one is realized?
They must go through the aspirant women judges program. They qualify to be candidates there. Because as I indicated then, the concern is always that they are not familiar. They have not practiced the law. They are not familiar with court processes and procedures. So that program is exactly meant to cure such shortcomings. It will help.
They are not only women, they are also men.
I'm thinking about that. Well, we may just have to expand it to include men. I'm sorry. You have to forgive my bias. Commissioner Magwanishe, I'm a woman. We've been at the bottom of the heap since the beginning of time. So when one thinks, they just think for the position of women. You are an afterthought because you own the field. You are the field as men.
No problem.
We'll have to accommodate men. That's a good point you raise.
No problem. And then what is your view with regard to the appointment of state advocates and prosecutors as acting judges?
I recall that this commission actually dealt with that issue. I'm sorry, Chair.
It was never finalized.
It was never finalized. Can I duck that question until the commission has resolved the issue? Commissioner, please. Look, if you insist...
Well, Commissioner Magwanishe is nodding, so I take that to mean that, he's prepared to, recant the question.
Thank you.
And proceed to the next one.
No, thank you very much, Chairperson. Yes. President Maya, my concern is that you have done something extraordinary. And I would hate it to that extraordinary thing that you have done to be a one-day wonder. Writing a judgment in an African language. And I know for a fact that even the JSC before this one, in the 5th administration, there were always concerns and issues raised by people like Commissioner Nokese, Commissioner Mutsecha, Commissioner Nyambi, about the issue of LLB, the inclusion of African languages, and you have moved a step forward. What is it that you will do to ensure that this is taken to the next level of ensuring that our languages are also used as languages of commerce? Writing a judgment in isiXhosa is a major step forward, and we would love to see many of those Setswana, Sepedi, all those judgments. But it needs a lot of resources, it needs a lot of commitment, not only from the judiciary, but from the state as a whole. But it needs a pioneer to pioneer that.
Yeah. Thank you, Commissioner. Well, you've given 3/4 of my answer. That it's a project that requires resources and a lot of commitment. No shortage on commitment, but resources are troublesome. Look, in the short term, I had hoped to have seen, because my judgment came out 2 years ago, I think. And thereafter, we happened to sit in another case which involved a closer accused. And I presided in that case, and I encouraged the scribe to do the same thing I'd done in AfriForum. So we actually have 2 judgments in isiXhosa at the SCA. And I hope that, you know, that example would encourage other people to write in their languages as well. It's not an easy thing to do, though. I grew up in a rural setting. I like to think that I'm fluent in isiXhosa, but I've discovered that, you know, we've been, I forget the word now, with interacting with other, you know, in cosmopolitan areas, we tend to lose the purity. It's purity. So that's where the resources and support come from. You know, we can't expect people to sit on their own and produce a fluent Setswana judgment. They would need assistance, and that takes money, which we currently don't have. But we need to have a policy on language. I'm trying to avoid going to this issue of language, of record, because it's implicated, I think. We should encourage all languages, all 11 South African languages, to be used in our courts as a matter of course. That's a long-term vision. At the moment, it's only English for practical reasons, which I think we can all sympathize with, we understand. But we can't, with our history, you know, turn our backs on our languages. So we need to do something about that. I think at policy level, because it's not something I've discussed with my colleagues at Heads of Court Cluster, I would need I would need to just discuss it with them. It's another agenda item for this judges' conference, to hear what our constituency feels about the issue of language. We know that Afrikaners are very passionate about their language, so we know what they will say. But as for the rest of us, we don't seem to be particularly interested. Well, we don't know, we've not asked people. That's why I mentioned the idea of debating, discussing it, just putting it on the table and hear how people feel about it and exchange views. I mean, it's a big issue, Commissioner, that you raise. Just see what we can do about it and involve other stakeholders. I mean, it's not something the judiciary can, resolve on its own. It needs collaboration. That's the best I can say.
No, thank you very much, President Maya. You will be the head of the entire judiciary if appointed. And one of the concerns I have is the mental welfare of judicial officers, especially those who preside in the criminal cases, with particular reference to those who deal with gender-based violence cases. What programs do you think maybe it would be part of the agenda item for that conference? What type of support should judicial officers be given? Because it's quite a lonely job and it does have a serious impact on their mental wellness.
Yeah. I agree with you. It's critical, Commissioner. The judiciary is one up on you. I don't know if I can ask my colleagues, assistants, but we have been working with the assistance of our department, the OCJ, on a judicial officers wellness program. I'm not entirely sure at which stage it is though, but it's something that it was one. COVID just interrupted a whole lot of things, but it's one of the issues that was top on our agenda for implementation. And it's something that is one of the things that we need to follow up on urgently.
Thank you very much. Thank you, Acting President. Thank you, President Mayor.
Thank you, Commissioner.
Thank you, Commissioner Magwanisha. Commissioner Muimang.
Thank you, Acting President. Good afternoon, President Maya.
Afternoon, Commissioner. And I see that you're wearing a mask today. When everybody else is not wearing it.
The interest that I have is in relation to the point that you made in the matter of AfriForum.
Yes.
The matter of AfriForum, which is a matter of public interest, and the judgment that is quite impressive that was delivered by the President. Just two areas that I thought the President could give just a response to allay the fears of the student body of UNISA, the council and the management. The council and the management on the agenda to transform the language policy of the university, because a perception could be created that the candidate for the Chief Justice, to a larger degree, was not sympathetic to the transformation agenda in terms of language policy of the university, which was informed by the dwindling demography of students that are receiving tuition in Afrikaans. which promptly was the rationale behind the commitment by the university to transform, or to transform the language policy that they adopted in 2016. Given the magnitude of transformation imperatives, can the president, in a succinct form, just to speak to that judgment, so that those that are listening and watching the interview, their fears could be allayed to say, look, we have a transformation champion who is a candidate. There are other reasons. Explain to them the rationality and the legality concepts that you applied to the decision that ultimately made you to distinguish the case from the Stellenbosch and the Free State University, because with Stellenbosch and Free State University, the changes in the language policy succeeded. Thank you, Acting President
Thanks,
Maya.
Commissioner. I do appreciate your question, because apparently I keep away from social media. I heard that there had been huge discontent concerning that judgment, in which the chair, I must involve him too, in which he also said and concurred.
I saw that.
Commissioner, let me just start by saying, I marched against Africans. When I started working, in fact, when I was invited to act at the SCA, I made it very clear to then President Howie, that I don't speak Afrikaans, which I passed with an A, with a distinction in matric, by the way. I'm not prepared to work on Afrikaans, because I had, from my childhood, scars. So unfortunately, previously, it's a language that I had a very negative attitude towards, but I'm a grown woman now, and that appears from my decision in this judgment. The simple answer, and you touch upon what I think Commissioner Tlepu said earlier about judgments being misunderstood. The simple distinguishing issue, the simple issue that distinguishes AfroForum from Stellenbosch and UFS is that UNISA simply did not do its homework that Section 29(2) of the Constitution enjoins it to do. We fully understand the need to transform. That's why Stellenbosch and UFS succeeded. But they had not done their homework to justify the implementation of the policy, without going through all the procedural and substantive steps that the Constitution requires. Nothing stops them from, I hope that's what the Constitutional Court agreed with us. I don't want to say they were just lazy. They must do, their effort was shoddy. I can't put it any, better than that. It was shoddy. And what I expect them to be doing now is doing their homework and, patching up where they had failed before and implementing their transformation policy. That's all. That's all there was to it.
Thank you, President Maya. Thank you, Acting President.
Thank you, Commissioner Muima. Commissioner Dodov.
Thank you very much, Justice Pete. Good afternoon, Justice Maya.
Afternoon, Commissioner.
I can see you have now settled quite well.
And I sense difficult questions coming from you.
Yes. I had the possibility to read your CV and your background on several occasions as I was preparing for this session. This is very impressive.
Thank you.
I'm trying to think of any woman who has risen to these majestic heights of success like you. I'm very much impressed, I must say. And I hope that young women of this country will look at you try to emulate your examples and virtues, which is very important in the context of our country.
Thank you, Commissioner.
Now, my first question is that I heard you talking passionately about transformation, but in that sense, you speak a lot about gender equality, women empowerment, and emancipation. You have spoken little about social justice. There are inequalities in our society. Opportunities not equal. People historically disadvantaged, not afforded access to court in a way that is appropriate. And therefore, in my view, this has got an implication to the judgments. What is your view on that? What is it that can be done in precision to really address issues of social justice if you are considered for this position?
I'm sorry that I did not, for the shortcoming, Commissioner. Another shameful, label we bear in the world is being one of, or if not the most unequal societies in the world. So social justice is key. And just speaking in this narrow context of being in the judiciary, the one way we can try to address that is making sure that our people have access to justice. That actually is key, having access to justice so that we can vindicate these, these rights that are promised in the Constitution. And I think that is the key role of the judiciary. That's how it can contribute meaningfully to the fight to make South Africa a better country for everybody.
As I was listening to you talking about women empowerment, will I be correct to assert that you subscribe to a philosophy of expropriation of legal knowledge without compensation?
Legal knowledge.
Yes, I want to test you on that.
I don't understand that question, Commissioner.
No, I mean in terms of making sure that young people especially are empowered, and those who are in positions of power and authority must proliferate that knowledge to young people without expecting much, including compensation to those.
Of course. Yes, it's our collective obligation to do that. Hence, mentorship is one of the key, things that each one of us must be engaged in. Mentorship of our young people and helping them in any way that we can. We have to impart any and all the skills and experiences that we have to the next generation. In fact, some of the current generation, because many of our people are suffering.
Now, Section 174, subsection 2 of the Constitution states that when judicial officers are appointed, we must make sure that they reflect the racial and gender composition of the judiciary. That is a factor that must be taken into account.
Yes.
But in terms of Section 9 of the Constitution, it speaks a lot about other factors like language, like culture, like sex and all of that. Don't you think at this stage we need to consider amending Section 174 of the Constitution to incorporate all of this, because they speak to issues of equality, not only on race and gender? What is your view on that?
In what way would we incorporate them in the provisions as they stand, Commissioner? I know it's my duty to answer questions and not ask them, but I just for
I'm
clarity.
saying Section 174 only speaks to race and...
It is narrow, you mean?
Yes, it's narrow in my view. There could be issues of geographic orientation of sex, of language, of culture, even of ideology, if you like.
I get you. The meaning of subsections 1 and 2 of that provision have been a subject of debate for a long time. Who is a fit and proper person? A judiciary to reflect broadly. How do you apply that? And I have a suspicion that the legislature couched them in this fashion very deliberately. Commissioner. And I want to believe that the Commission, throughout its history, has been able to give content. Well, maybe in respect of some aspects and not so much on others. Because the race issue we've done very well there. At least I'm speaking for my institution now. I mean, all heads of court are black, are Africans. We have good statistics in that regard. It's only in respect of women, and we've already taken great strides in respect of the magistracy, but elsewhere we're still lagging behind. And I want to believe that once you speak about race and gender, Section 9 is implicated. Equality is there. You can't overlook it when you apply these provisions. I don't know if I'm making sense.
It's okay. I just wanted to test your view on that. My last question, Justice Peter. As I understand, and this can be vindicated in so many ways, when in 2017, when you were here, interviewed for the position of president of the SCA, you outlined, as you did this morning, what was your vision, and it is quite evident that a lot has been addressed in relation to what you said as a vision. But we have not spoken about the improvements, if any, in respect of the briefing patterns. Whether do you see improvements in that respect, where young advocates or attorneys are taken into consideration?
No. The answer is unequivocally no. At least if one, the only yardstick I can use is just checking who appears before us. And the answer is no.
It's no, as easy.
Yeah, and I do speak to a lot of young people. I know, especially young women, who do articles, who go to the bar, but then they don't get work, and they end up being sucked back. I mean, the problem we've been talking about for a long time. They end up going to the job market because they just don't get work.
All right.
So there's been, and I had said then that the government, being the biggest litigator, must make sure that our children, our young people, are given work. And it does not appear. In fact, one hears scary things that the minister knows about them. I don't want to talk about here, about what happens in the state attorney's work to be able to get work. So we have problems. We have problems.
Thank you very much. Thank you, Justice Peter.
Thank you, Commissioner Dodovo.
Justice, may I follow?
There is a follow-up question from Commissioner Mandisa.
Thank you very much, Acting President, and thank you, Judge. Judge, you raised this issue quite early in your vision about our inability to brief young black women to represent us, particularly government, the state government entities being the ones who are the highest litigants. The question I have to you is, the problem with executives generally is that you are advised by the state law advisors. And the state law advisors will say, ma'am, for the particular case you need experienced lawyer, you need experience that, experience this, and which at the end you find that it takes you back to people you would have wanted to avoid not to avoid out of malice, but more because you want to empower a black woman in a corner who you know, in fact, has a practice and just needs to be propped up by us, those of us who are either in government or even in parliament, as I'm in parliament now.
Yes.
So what would you advise the state law advisors to do? And I'm raising this deliberately because the minister is here, Skosana is here, of course the DG of the department is not here. But what really would you advise should be done? Because indeed, generally, it is very easy to dismiss companies, practices which belong to younger people, in fact, both men and women, not necessarily women companies only. And I think, how would you use your own experience and your own position, if you were to be appointed here, in ensuring that this word is spread, that people need to come out and brief the younger ones so that they prepare them to be eligible to be appointed into these positions which you have found yourselves in?
Thank you, Commissioner. I don't know if there's any more effective way of disseminating this message than doing it from this platform, and I can promise you, you know it. Since the JSC started sitting, the issue of briefing patterns has been on the table. We've always had a cabinet minister here and members of parliament, and they would hear what the candidates said about briefing patterns, and the members of the professions who actually feel the pinch because they're actually they would have a lot to say about it. But it does not seem, the message does not seem to permeate. I hear what you're saying about, litigants wanting experienced lawyers. Of course, we need experienced people who make sure that we get the relief, the orders we want. But it is done by some. Get your experienced lawyer, but issue an instruction that if it's a senior counsel, they must be accompanied by, black and women juniors. It's your brief, it's your instruction. It's very simple. And we are not entirely sure why it is difficult for our state organs to do that, because we don't really see it in practice. Thank you, Commissioner.
Can I make a follow-up? Maybe that will be my only question. Then
Is it a follow-up question,
Yes.
Commissioner Malema? Please, you may proceed.
President, I also have a follow-up, Acting President.
I just want to understand, President Maya. Does the appointment of women into positions of power guarantee that women lawyers will get a brief? I'll tell you why. Because there are a lot of women who get appointed. The Speaker of Parliament has been a female. Without fail, Parliament is represented by men. My colleague here from a beautiful province of Eastern Cape, JSC, said it here yesterday that banks hate black people. But not only that, they hate women. Maria Ramos is the most celebrated woman. She was a CEO of ABSA, where women being briefed at ABSA. Maria Ramos was a CEO of Transnet, where women being briefed at Transnet. So, does the empowerment or appointment of senior women into strategic positions translate into automatically women getting briefed or I don't know how to put it, because it looks like there is generally also the struggle that women have to fight amongst women themselves, where women just have a problem of empowering other women. Parliament is a typical example where we sit. I litigate with Parliament all the time. I'm likely to do that in the next few days. So you are guaranteed it's going to be a man. And Parliament is headed by a female. Before that it was a female. Parliament sometimes even goes to the extreme. It doesn't just brief men, it briefs white men and headed by females. So where lies the problem and what can be done? Because we are fighting at this level, let's empower women. But the next thing, it doesn't translate into any practical intervention in changing the status quo of women. Thanks, President.
Oh, thank you, Commissioner. Yeah, it's a tough one. And I would say, just like this commission does not appoint candidates simply because they are black and female to fulfill the injunction in section 1742, they also have to subscribe to the values of the Constitution. I think it's the same phenomenon. Not all women will be passionate about the empowerment of women as human, as men. Not all of them believe in some of these noble, endeavors. But by and large, Commissioner Malema, women will make sure, I'm trying, English escapes me now. By and large, women care about their communities. That's why there's a general, that old saying that if you educate a man, you educate a man, but if you educate a woman, you educate a community. So generally speaking, women have that nurturing quality that wants to ensure that actually not just other women as well, but society, is improved, is improved, for lack of a better word. But it's not always the case. You're quite right. Hence, we gained notoriety for the pull head down syndrome. I mean, we are always teased that we are in the majority in the world. So if we had it in us to support one another, we should be leading the world in all spheres, but we don't. So, yeah, it's a human problem.
No, thank you, President. But this is just a frustration I want to raise with you, and you are free not to comment on it, because, I thought I will never get to engage in a struggle to give young, poor, struggling women free sanitary towels at the UCT, for instance, at UNISA, for instance, the latest being Walter Sisulu University, where vice chancellors are women who should be appreciating the meaning of such a requirement. But now you have to go into fight with such women about making such facilities available for poor, struggling young women. So, and when they came in, there were ululation and celebrations everywhere that now a woman is coming in, the burden is going to be lessened on the poor and women in particular and all of that. But it looks like things continue as they were. Thanks, Chair.
Thank you, Commissioner Malema. Honorable Minister.
Yeah, no, thank you, Acting President. I just want to come on this issue for the comment of the Judge President. In the last JSC, I think we did report that there was a legal sector code that was being drafted.
Oh, yes.
And as we speak now, it is on the table of the Minister of DTCI, which we have done through the advice of the Legal Practice Council. But I'm bringing the legal sector code because I think it has got a very good innovative way that it is going to be able to measure the issue of the briefing pattern, in that it proposes that we must establish a council that will monitor all the briefing patterns. It does state the quotas and the codes, but it also says the council must have powers to monitor, to summon departments, to summon whoever within the state to provide the information in terms of the briefing patterns. And I believe that the profession will be able to, for the first time, know who is transmitted briefing, for how much, and how much went to black practitioners. Like we do with the state attorney, where it is published how much and so forth. And I think that could be a good start for a solution, particularly when there is a monitoring or implementable kind of a measure, because the current situation is that while we do have policies, but there is no monitoring mechanism. So I'm not sure what will be your view for us to ensure that indeed it does happen, whether that monitoring mechanism will be enough, or you may think we may need further instruments to ensure that what the commissioners are saying, what is in the policy, it does happen.
Look, first, that's a brilliant, excuse me, initiative, Minister, and I'm happy to hear that there's been progress in its processing. But you know, just like we have so many good laws, we have a beautiful constitution, but implementation, achieving the result is usually a problem. I'm just trying to think now that this monitoring body comes up with these statistics, it summons, what other powers would it have other than, what you mentioned is all that it would have. What teeth would it have to ensure that the recalcitrant, stakeholders live up to the expectation? Has it been given any powers to punish, to, what is the?
Yeah, I think this, with the indulgence of the acting president, to allow that this could be the first time where an interview we can ask a question to the panel.
I'm sorry.
With your indulgence,
Is this not now degenerating into a dialogue between you, Honorable Minister, and the candidate?
Yeah, I don't know. I just want your guidance because she has asked a question, and yeah, I don't know. If
I'll
that
give
will
you a
be
minute, Honorable Minister, to wrap up.
Yeah, no. I don't want to waste your time. I just wanted to check whether I can answer the question, and I think even Memlepu could be helpful to that. But it does have some kind of powers in terms of the PE scoring and all that, which then, whichever may not be briefing, those scoring could be affected, including the issues in terms of the budget and all that. That will be what then the monitoring body. But the fact that that information is also public, anyone can use it to also litigate against that institution, to say you have committed to do this, you did not do it.
Well, the issues you mentioned then sound like good in incentive. If someone is going to feel the pinch, then they will comply. So if that council is empowered, is given as much power as possible to make sure that the recalcitrant, the offenders, are punished somehow, then that should take care of the problem. And if we see that down the line those measures are not quite effective, then we go back to the drawing board and see how else we can enforce compliance.
Follow up. Follow up, please.
Yes, Commissioner Mbofu.
Yeah, I'm done, Acting President.
Thank you. This is just a follow-up. Do you think that a black-led government, progressive government, with men and women who know the plight of black professionals should be proud that the only achievement they've made is to be monitored? Why do they need to be monitored to do the right thing? Why do they need to be monitored in order to empower people like them whom they know have been sidelined in this profession to the extent that you have explained, where you yourself have not had access to commercial work, which is the exclusive preserve of white practitioners? Secondly, is the examples that have been given, including I've been litigating now currently against the Speaker of Parliament, who's a woman, the previous one and the current one, against against the NPA, which is headed by a woman. 2 days before I came here, they have 2 or 3 white male senior counsel. Why do they need to be monitored in order to do the right thing? Don't they know that they must empower women and black people?
Well, it's nothing to be proud of, Mr. Mbofu. All I can say is it is what it is. People are not doing the right thing, and then they must just be monitored.
Thank you.
It's lunchtime.
Mindful of the fact that I earlier on indicated that we are expecting load shedding at 2 o'clock, and that we would adjourn for lunch at 10 to 2. According to my watch, we are 12 minutes to 2. I don't think that there would be any virtue in calling upon Commissioner Xaba to commence with his questions at this stage. So this will be the convenient stage to take the lunch adjournment, and I guess we could resume at 2:45 or 10 to 3 or 3 o'clock. One hour will take us to 10 to 3. Thank you. So that's it. We'll resume at 10 to 3. Thank you. Do you have your ducks on the row, President Maya?
Yes, I do.
Thank you. Over to you, Commissioner Xaba.
Yes, thank you very much, Acting President. Good afternoon once again, President Maya.
Afternoon, Commissioner.
Good. This morning you presented your vision, and I must say I can't find fault with it. But I just want to take you on the point of transformation we raised earlier on. In 2017, when you were interviewed for the position of president, You made gender parity as one of your key focus areas, and I must say you have delivered on it.
Thank you.
And the record speaks for itself. 11 women judges to 12 male judges. I just want to contrast that to the heads of courts. In 2017, there were 4 female heads of court. 4 years later, let me not say how many there are now. In your view, has that situation improved? Then there were about 13 heads of, 14 heads of court, 4 of whom were women. The question, has that situation improved?
Thank you, Commissioner. No. And actually, it's likely to regress shortly. The first woman JP in the country, JP Leo, is retiring soon, and we have one candidate to interview to fill that position, who's a male. So we'll be one short, actually.
So what is the position currently?
It has not changed. Well, the only change is what happened in October when we appointed 3 women DJPs, which is a big improvement. It is a gain. One has to acknowledge that. So there has been, but we're looking for JPs, the actual heads who sit at the top of the table.
So you are actually confirming that the situation has regressed? Yeah. And that's 4 years later. Now, from your own observation as a member of this body since 2017, what could have been the reason, and what can be done to overcome this problem? Tapping on your experience, having improved the demographics in your own court.
I said in one of my long-winded responses earlier that when women are appointed into the bench, they must be given the same opportunities as their male counterparts who are no better endowed in any way than they are. Women must just be trusted to take up leadership positions, Commissioner Klaba, that's all I can say. Give women an opportunity to act as DJPs, as JPs, that's where it starts. So give women a chance, because there are women in all divisions of our courts.
You are right, you did opine on that. Let me just raise the issue of the Concord. See, Concord releases judges from active service, relatively young, and on a full salary for life. Don't you think that that is actually escalating the problem of brain drainage within the system, and that at some point this thing will catch up with us, because we seem to be releasing at a much higher rate skilled judges, as I said, relatively young. What is your opinion, and what can be done about it? Thank you.
It has its pros and cons. The pro being that I'm sure none of us want to see what happens in the US when people die in their 90s on the bench. I don't think that's a good thing. But then, as you point out, we lose relatively young judges who still have many years to give, and they live with that institutional memory and experience. And ironically, most of our retired judges are working in Namibia, in the neighboring countries. And there's so much to be done here, you know. We don't even engage them meaningfully.
Don't you think that, my last question as a follow-up, President, we discussed this with one of the commissioners, that would it not be an ideal thing to do that when you get discharged from the Concord, we appoint you, or we reserve appointments to specialist court for such people, so that we retain this institutional memory and we retain the skills that have actually been acquired over time. I'm reading this in the context of the vision that you painted here this morning. Has that not been discussed? If it has not, what is your take on this? Reserving positions, senior positions in the specialist courts for people who get discharged in the manner that we have just explained?
I'm not aware that it has been discussed, Commissioner. That's a fine idea. And in fact, DP Pese and I are contemplating a number of retired judges from the Constitutional Court. I can mention Deputy Chief Justice Museneke, Justice Yakub, were keen after their retirement to go and act at the SA, I suppose for the experience and just to, because it's a different court, and to impart skills, yeah. But for some reason or the other, that never came to pass. Now, DP Pese and I have been talking, because we actually have one of such retired judges who's keen to go and act at the SCA and assist in because we've been appointing younger judges, not as experienced as we used to have back in the day. And that kind of skill would be precious. I don't have a clear answer for you now, but what I know, and it's something that has exercised my mind, that has worried me for a long time, is that we need to use those judges. We need to retain them somehow and use them. I think, well, I guess we'll have to just decide precisely, think about it, debate it, and see how we can best do that. But it's a skill that is lost to us that we should be using.
No, thank you very much, Judge President. Maybe it's a question left for the Minister to look into, because we have invested so much in those people as a country. And even when they've been discharged, we continue to pay them full salary. All right, but that's not an issue. Thank you so much. Thank you so much, Acting President.
Thank you, Commissioner Klaver. Commissioner Lucas.
Thank you very much, Acting President. Good afternoon, President Maya.
Afternoon, Commissioner.
Yes, today you are on the other side of the table. But thank you, welcome. Let me begin by saying there was a lot said about women's empowerment, gender equity, and things like that. The anomaly in what is being said already is the fact that we are going to interview 4 candidates, but you are the only woman. Not even there was the principle of 50-50. Possibly, I don't know, but that shows, and particularly also when we see how you have been supported in your nomination internationally. Yeah. You have become more or less the hope and the pallbearer for women's aspirations when you are sitting here. So just for the mere fact that you broke the glass ceiling to be able to sit here to do the interview for Chief Justice, we want to commend you. We really want to commend you, and say that you have made us proud as women of South Africa. I've said it before, if a woman can even just be nominated as a president, it means that we have broken the glass ceiling. And that is what you have achieved. I will allow you to get to just...
I'm sorry, Commissioner.
It's fine, you don't have to be sorry. We are emotional beings as women.
Yeah, that's what you are accused of.
Onze die depressie nie, want onze hele is ons model.
And men as well.
So it's fine. I think no one will even think less of you if you become emotional. I'm sure if your mother is still alive today, she's very proud of you. That's how I feel.
Thank you.
So I just have two issues that I don't think it is questions, but it's issues that I think I should raise. I will be, if you are appointed, it will be one major achievement for me if we can really achieve the inclusivity of the judiciary. By making sure, particularly at lower levels, we address the issues. Sometimes you speak about our efficient...
Just a second, Commissioner.
It's fine. Today and yesterday we heard how efficient and effective the Supreme Court of Appeal is and the Constitutional Court and so on. And I fear that people at that level become very complacent and they don't know at the level of true service delivery. It is not the experience of our people. That is why the issue of inclusivity that you spoke about, and also one single judiciary where things could be coordinated at a better level, it's commendable, it's notable. Because I think people at your level can become very complacent and in a comfort zone because of having the kind of support that they can garner, and not necessarily having the kind of volumes of contact with people at a grassroots level that you see in the magistracy. So there is one or two issues that I've experienced that is an issue. You mentioned the issue of incorporating the traditional courts. But even if we have the traditional courts, I don't know how effective they are. Because one of the issues that came out in our consultation with women across the country, particularly in the rural provinces, is the issue of how customary law is not working for our rural women. It's one of the issues. Secondly, the other issue is how courts at that level, rural as well as urban, is just not working for the vulnerable people. And I just, in a very short few sentences, if you can indicate how you think this single judiciary, of this single-minded judiciary, can address that kind of issues. I don't have to speak about women, I don't have to speak about gender, it has been properly addressed. And even if you don't get this position, which I sincerely hope you got on behalf of us as women, God be with you. Thank you, Chairperson.
Thank you so much, Commissioner. You got me crying, and I don't usually do that. Short answer. The idea of bringing traditional courts into the fold, into the mainstream, is to monitor and guide and be of assistance to those courts to ensure that they deliver justice to those communities they serve. That's all I will say on the subject, Commissioner. Keeping them close to the other rungs of the judiciary, I believe, will benefit them greatly and will give us a chance to observe exactly what goes on there and what does not go on there that needs to be done.
No, thank you. The commitment is enough. Thank you very much. Thank you, Deputy.
Thank you, Commissioner Lucas. Commissioner Singh.
Thank you very much, Acting President. Good afternoon, President Maya. Good to see you again. I want to start off by saying that we've spoken a lot about gender transformation this morning. And many of us as commissioners have sat around this very table or other tables interviewing prospective candidates for appointment, both men and women. And we realize that our responsibility is to create a public platform for the candidates to express themselves, and secondly, to recommend to the President, who should be appointed. But the final call on who is appointed lies with the President himself. Now, I just want to share my disappointment that after the last interviews on the Constitutional Court appointees, that of the 4 very capable people that we recommended as a commission to the President, he chose to ignore the 2 very capable women and appoint 2 men to those positions. Do you have any view on that? Do you want to express a view? Because I certainly was disappointed that that had happened.
Utter disappointment. A feeling of utter disappointment, Commissioner. And I think I speak for a whole lot of South Africans, especially women.
Thank you. I'm glad I was not the only one that felt disappointed when I read this announcement by the President of the 2 people. Not that they're not capable of being Concord judges, they're extremely capable, but I would have thought that given the times that we face and given the imperatives that we have as a country for gender equality, etc., he could have considered at least one of those women. But anyway, I hope the Minister will take that up with the President when he meets him. It's not for us here. My next question is related to the issue of restoration of trust in the judiciary. Now, we know the judiciary is a critical key to our democracy. And earlier you spoke about the Afrobarometer survey, which was quite disappointing because, just to quote, it held that respondents with, quote, greater experience of lived poverty and less education are less trusting of the courts than are more secure and educated respondents. That's what it found. Now, what in your opinion could be potential reasons for this decline in trust in the judiciary by ordinary people? And how do you hope, if you're appointed as Chief Justice, to reverse this declining trust in the judiciary?
Self-introspection is a very difficult exercise, People don't like to be criticized. It's even more difficult to look at yourself critically. But look, I'll venture, I'm speculating now. It must be that courts are not delivering what they expect them to deliver. What else could it be?
So do you believe that these people have legitimate grounds to distrust the judiciary at this moment in time, given the turbulence and the political pressures that we are facing in the country, and some of the judgments and the delayed judgments, etc.?
Look, as I said at the outset, Commissioner Singh, while the institution does execute its constitutional mandate, it's not perfect. So there are definitely things we are not doing right, which all of us around this table know. So we need to get, as my children would say, just get our act together as a judiciary, pull up our socks and clean up.
Absolutely, and I hope that the new Chief Justice, whoever that is, together with the Ministry and the Department of Justice, can get our act together to deliver justice to the people of South. Because I was looking at another survey as well, which was included in the OCJ's strategic plan, based on 2018 Victims of Crime Survey, where 50.85% of households are, and I quote, not satisfied with the way in which the courts deal with the perpetrators of crime, close quote. Now that's 1 in 2. Now that's really an indictment on us and our judicial system. If 1 or 2 people that were surveyed can have that kind of opinion. So it's a tall ask for the new Chief Justice, and I do hope and pray that you have the strength and the character, if appointed, to change things around. The next question will relate to the objections. Now, we've gone through the nomination.
Commissioner Singh, sorry to interrupt you. Before you pose your next question, I just want to ask President Maya to pull the microphone close to her.
Thanks for the reminder, DP.
You're most welcome. You may proceed, Commissioner.
Thank you, Acting President. I think Honorable Lucas, Commissioner Lucas, has spoken about your nominations, and you spoke about it, international nominations and people who supported you. But we also have to look at objections that are submitted to us. And I think you've responded adequately to the Tennyson objection in writing, but perhaps you want to tell us about it. And there was another Simon Monke, is that? The second, sorry?
I don't know about another one. I was only served with the...
the other objection is in our documents here. Simon Mokone.
No, I'm not aware of that one.
That came through as objection number 3 in our documents. Tennyson was objection number 1.
I know all about Tennyson. Maybe I can quickly deal with that one, then we'll get to this other one.
Okay, thanks.
I think Mr. Tennyson simply just took a dislike to me. He started in some magistrates' court in the Western Cape, an eviction case. An elderly gentleman let me leave it at that, lost the case, having created a whole lot of havoc there. I mean, he was asking magistrates to recuse themselves, that kind of thing. Went to the High Court. The state attorney, because the Minister of Justice was I believe there's still, he contemplates furthering this litigation of his. So Minister is one of the litigants represented by the state attorney, of course. The state attorney ultimately, after an avalanche of interlocutory applications, brought vexatious proceedings against him. So he was barred by the High Court from launching litigation in the High Court or in any court without permission, leave of a court. He's lost naturally. Case found its way at the Supreme Court of Appeal. 2 judges. He went through, I think, about 5 judges in the Cape High Court who are also respondents in this litigation that he brought against us, suing us for millions. I don't know where I'm going to get that money. So SCA, 2 judges dismissed his application for leave to appeal, came to me on Section 17(2)(f) of the Supreme Court Act for reconsideration. I found no merit, I dismissed it. It went to the Concord, headed by DCJ Zondo. Justice Madlanga was there, and a bunch of other judges. They dismissed it. Now he sues us. I even forget what he says, he accuses me of. But now he says he intends launching what's the Rule 42, a rescission application. I don't know in which court, and that application has not yet been launched. So that's the long and short of it. My order was confirmed by the Constitutional Court, and that's the end of my story insofar as that is concerned. Now, about what is this other one about, Commissioner? If you can assist me. I found it.
Simon Mokone.
I'm sorry, I missed this. How could I miss it?
The other one I just ignored because I don't think it has any merit.
I see that he objects to my candidature, my ACJ Zondo and JP Mlambo. He challenges the whole nomination process. It seems his gripe is against the procedure, the process
yes,
followed by
yes.
the president. I don't know what to say to that.
And then he refers in 9.3 SCA, President Maya, JSC 96521. So
I know nothing about JD. That has not been brought to my attention. I don't know. I know nothing about that complaint, Commissioner.
all right.
I'm sorry, I can't help you.
I think we can't take it. The last question, Acting President, is I think you would recall, President Maya, that in a previous interview, when there was an outburst or real mayhem created when a certain recording was played to us. I think some commissioners are laughing about it. And there were certain questions that came from the chair at that time. In hindsight, I'm very glad that you've applied for this position, by the way. But
I didn't apply, I was nominated.
You nominated,
yeah,
and by so many people. But in hindsight, what do you think, now if you have to look back at what happened then, is there any comment you would like to make now about what happened then?
All I can say is that had absolutely nothing to do with me. A group of magistrates thought I would make a good Chief Justice, and they did their thing, held their meetings without even consulting me. And then I heard that a voice note singing about me had gone viral. Nothing at all to do with me. And now this thing is sprung upon me here. And I was most embarrassed. Those who know me, Mr. Singh, would know that that is not how I live my life.
Thank you very much. Thank you very much, Acting President.
Thank you.
Thank you, Commissioner Singh.
Follow up, Acting President.
For Honorable Minister.
No, thank you. I just have one follow-up, Judge President, on the question with regards to the last appointments, in that the President in 2019 appointed 2 Concord judges, Zukisa Chitri and Majid.
Yes.
And last year, as Honorable Singh has said, as an appointing authority, is the President not bound by Section 174(2) to look into the whole broader issues?
Of course, Minister.
Okay, no, thank you.
But we still have our hopes and aspirations, and we get disappointed if we don't get our way as humans.
Thank you, Honorable Minister. Commissioner Mbofu.
Thank you, Acting President. Well, let's just start with a follow-up on the Minister. 174(2) reads like this: the need for the judiciary to reflect broadly the racial and gender composition of South Africa must be considered when judicial officers are appointed. Can that section be used to exclude women from being considered or appointed to the Constitutional Court?
Never.
Thanks.
Not on the current facts when,
Thanks.
not be long-winded.
Thank you very much. Okay. All right. Okay, let me come to my questions. Well, before I do that, I think I must also start with a declaration. I don't know if Mr. Ntsabeza SC is still here, so I wanted to make a declaration for him first. That one of your mentors and the people who you say brought you here was actually sitting here in the room. I'm sure him and Judge President Hlophe are very proud of you right now, whatever happens. Well, now my declaration is that, Acting President, President Maya and I did pupillage together. And we spent a night together.
Please explain But Commissioner Mbofu.
No, I'm not going to explain it, President. No, Acting President, what happened is President Maya and I and a late gentleman called Mr. Mgijima had a study group as pupils. And the three of us one day sat before an exam of civil procedure, sat in the inner chambers library, studying for the following day's exam. And it was the first time in my life I did this thing called cross-nighting. We didn't do it deliberately. I'm just attesting to her industry. Because of her, we worked there until when we realized it was actually the time to write the exam. That's how we managed to spend the night together. And the only witness is unfortunately departed, so it's just me and her now. Thank you. President Maya, no, I was telling that story really to attest. I think the very first sentence you uttered this morning when you were giving your vision was about that word industry. And I see some of the people who nominated you also use that word. And the serious part of that story is the fact that I'm a first-hand witness to how hard you work and how you could make, as I say, make me have to work the whole night through. Now, I want to ask you about transformation. As you know, I sit here, occupy this seat for, as representing advocates for transformation, which is part of the GCB. But before I do the questions on transformation, and because one of them was covered by Commissioner Singh partly, I see that you wrote in 2007 a paper called, or delivered a paper called The Structure and Function of the South African Courts, which was delivered at an SCA open day on the 30th of May, 2007. Now, the reason I'm raising that is because I really would like, I'm very excited right now because I've had this idea and I've been threatening to write about it, of collapsing the SCA and beefing up the Constitutional Court. And when Justice Matopo and you have raised it formally, then I'm quite excited. And I want your comment, because my view on this is that it must be done. No, obviously not haphazardly. We need a lot of thought and writing about it. But would you agree that one of the quid pro quos for that would have to be strengthening, and I don't know exactly how, but strengthening considerably the appellate capacity of the divisions, of the law divisions. And in fact, in my rough model, half of the people in the SCA would go to the Concord maybe, and the others would go towards strengthening that appellate capacity of the divisions. Now, so I'd like you to comment on that one, but secondly, to comment on if our model, I'll call it our model for now, ever works out, what that would do for access to justice in South Africa. Because right now, an ordinary person like me, if I have a case here, then I must go to the full court, then I must go to the SCA, then maybe I must go to the Concord. It's completely impossible. So that's the second aspect, is the access to justice issue. And thirdly, the fact that this whole AD, as I prefer to call it in this context, is an anachronism anyway, which maybe was part of the 1994 compromises to keep it. 30 years on, shouldn't we have a serious look at the model that you and Justice Matopo seem to favor? And what should we do to develop the idea?
Thank you for the questions, Commissioner Mbofu. about collapsing the two courts, that would contribute immensely to access to justice, because it would take out, in fact, it's not just one level of the appellate process. Remember, when you lose at the High Court, you have to apply for leave to appeal, then the judges may refuse, then you seek leave from the SCA, it grants you, you go through there, and the two judges say no, it comes to me. So by taking out the SCA from the equation, you know, you'd be cutting off a huge component of the litigation costs involved in an appeal that will ultimately end up in the Constitutional Court. In the Constitutional Court. So that would be a big advantage, a big plus of that model, of your model. As you said, it requires careful thought. I mean, it can't be done haphazardly. It would require resources. I mean, how do you beef up the appellate, well, which would not really be so much of a problem, beef up the appellate process in the High Court. We already have 3-panel
appeals,
full court benches. Maybe you tinker with the numbers, increase them, you know, things like that. But it does require careful thought. You know, you don't want to throw out the baby with the bathwater. But no question about it, in terms of litigation costs, it would work, you know, like magic. And let me not say more on that.
Okay. Now the same question, but now looking at it, assume you get appointed.
Yeah.
As a Chief Justice, how would the increased complement in the Constitutional Court, assume we do away with the on-bank requirement of the judges having to sit all together, how would that then assist us? Let's assume we then have 20 judges of the Constitutional Court, and on your model of 7 or 9 minimum sitting.
As I said earlier, the immediate advantage would be that you'd be able to have more than one panel of judges sitting. Well, there's only one court, but they sit only twice or once a week. So you'd be able, I mean, we can't avoid the fact that litigation has grown tremendously. So there's lots of work, and I think that could help. I mean, with the general jurisdiction there, it would be a boon. So you'd find work for those judges. And as I said, is it Section 172? I mean, it contemplates that you still have your constitutional matters, and then the matters that raise an arguable point of law of general public importance, which ought to be considered by the court, then those would be your 2-panel, your 7-panel matters. But if you still need, there's a matter of great constitutional importance, you still have your 11 or whatever number sitting.
Thank you.
So no one would go, no one would sit idly in their chambers with no work.
Yeah. Thank you. Then there's an issue which I'd like you to help us with, to do with not just this process. Again, you'd be chairing the JSC, obviously, if you are appointed. And it seems to me that there is an issue that we have overlooked. We might have changed ourselves as the JSC. And it goes even to this process. Whether there's room for us to recommend, let's say, recommend more than or less than the number of candidates, if you know what I mean. Let's say here to recommend 2 or 3 or 1. Now, the point I make is that Sub 174(3) of the Constitution says the President, as head of the National Executive, after consulting the JSC and leaders of the parties represented in the National Assembly, appoints the Chief Justice and Deputy Chief Justice after consulting the JSC, and appoints the President of the President and Deputy President of the Supreme Court of Appeal. And then that's duplicated, obviously, with the Chief Justice, the other judges of the Constitutional Court are appointed by the President as head of the National Executive after consulting Chief Justice and so on. Yes. And when the JSC does the list. Now, would there have been anything to circumvent the situation that Commissioner Singh was talking about? Would there have been anything against this Constitution if in October, for example, we had said to the President, here are your 5 names according to the Constitution, but we as the JSC would, in that list, we're going to rank the people. Yeah. In other words, we say, number 1 is Justice, I won't mention them by name. Let's say the woman, one of the women judges. Number 2 is so-and-so, number 3 is so-and-so. Of course, the President can still overrule us. But is there anything preventing the JSC from saying, these are the people, this is the list, but this list goes like this?
Not from my reading of the provisions, Commissioner Mbovu. And one has to ask the question, I mean, for these particular sittings, what would be the point of the President sending 4 names to the JSC and the JSC throwing back 4 names to the President? Why did we go through all of this? Absolutely. Surely the JSC must have the power to rank. Oh, I don't know what else you can do, but you have certain powers.
Yes, thank you. Then, if we may then go to the issues of transformation. Acting President, please bear with me. The first issue has to do with women empowerment, a subject that I feel very strongly about, and I know you feel 100 times stronger about. There's a terrain that we all scatter around, particularly when it comes to gender empowerment. And that has to do with what in the feminist movement is called relative disadvantage. The position of black women, African women in particular, vis-a-vis white women. And in South Africa, it's a contradiction, and I'd like you to comment on it. Or for those who don't do dialectics, we'll call it a paradox. And it's something like this, that in the struggle against racial oppression, black males are your friends, and white women are your enemy, quote unquote. But in the struggle against gender oppression, white women are your friends and black men are the enemy, part of the enemy. How is that from a black woman's point of view? I'm now talking about the profession and the judiciary. How should we address that relative disadvantage in making appointments, in briefing patterns, and all the things that we've spoken about? Sorry, the second part of that question is what is the role of the Office of the Chief Justice in particular in ensuring that what you see from the bench, which is that the government is mainly represented by white male advocates. Many other leaders of the bench have told us that that's what they see, at least at face value. Is there any role that the Chief Justice or the bench as such can play in nudging the state, the reluctant state, away from that? But I'd like to start with the gender question.
In relation to the first part of your question, all I will say, Mr. Mbovu, Commissioner Mbovu, is that black women have always been at the bottom of the very bottom of the heap, wherever you go. Read what you will in that statement. regarding the role, our role in changing the situation, I'm not entirely sure how much more the judiciary can do to nudge, as you call it, the organs of state to do the right thing, other than to shame them on public platforms as we do. I really don't know. I mean, we can't force them not to brief their white silks. We can't tell them not to do that. But we can make the point, as we are doing now, that what you are doing is wrong on public platforms, so that all South Africans know, hear about what's going on. That yes, you can, no one is saying don't use white silks with their, wealth of experience. But you can't just let them eat the cake alone. Make sure that you empower the needy ones as well. There's enough to go around for everyone.
Yes, thank you. And for that, we can't blame the white lawyers, because what must they do? If somebody brings a brief, I would take it too.
Exactly.
Yeah. Okay. Now, okay, that's fine. I think we've covered. The last question then is just to piggyback on Commissioner Singh's question, because I was going to ask you about the disappointment that you must have felt when you were this side of the table in October.
I'm sorry, Mr. Mpofu, I just
No,
no,
don't worry. I was just simply saying that I'm piggybacking on Commissioner Singh's question, which you have already answered, about the disappointment you felt when, in October, you with us sitting this side made the recommendation and it was ignored of two capable women. But I wanted to link that to you, and you don't have to answer this. I'm putting you on the spot. For you, this was not the first experience. In 2012, you came here and you were interviewed for a position in the Constitutional Court. And you and a man, Justice Zondo, were recommended. And the president then, President Zuma, overlooked, that's my word, not yours, overlooked you and appointed Justice Zondo to the Constitutional Court. Now, how did that make you feel? Obviously, at a personal level, you were disappointed. Yeah. We don't have to go there. Yeah. But in terms of whether the state was serious about the imperative, let's assume, well, I'm told that you interviewed very well and greatly and better, but I can't say because I didn't watch those interviews.
You were not there.
Yes, unlike these ones of last year. But let's assume, for argument's sake, you interviewed equally, you were equally good. What message did those actions of former President Zuma, how did you interpret that outside of the personal?
Well, it was, here we go again. That's the lot of women not taken seriously. Right, I don't know what it was his prerogative. I don't know what his motives were. But I believe that I was, well, and many people, those who were here and others, were satisfied that I was a worthy candidate. I'm not saying I was a better candidate than my colleague, but having regard to the demographics and the injunctions of Section 174, I think it was an opportune moment to appoint a woman, but it wasn't done.
Thank you. Well, let's hope history will not repeat itself. Thank you, Acting President.
Thank you, Commissioner Mpofu. Professor Schleber.
Thank you, Acting President. President Meyer. When you spoke during your presentation of your vision, you indicated that you would like to see that the judiciary be combined as one. What is your vision specifically? How do you see the interaction? Perhaps I should put the question straight. Do you think it's time,
Or is it something that you would consider to have a career path for judges? Could you elaborate on that, please?
The first advantage is that if you, it's what the magistrates are saying now, that if we were linked to the judges, we would be under the OCJ and would not be, just at a practical level, would not be experiencing the problems where, you know, the Department of Justice, sorry, Minister, is just not taking good care of us. Just from that point, they would be better resourced, because I'm not saying this senior judiciary has, you know, enough resources, but we would be able to find creative ways of making sure that everybody, you know, gets the necessary tools of trade with the legal that we are given, so that at least the course can function. What you say about a career path is something I've chatted about with colleagues. That if we are this disparate institution, I don't even know much about the small claims court. When I need to go and check online exactly what's going on there. I didn't even know, because I don't usually pay attention what the jurisdiction was there, and I was surprised to see that, oh, it's 20,000 rand now. So the lower rungs of the judiciary are neglected. And if we keep them close to us, then we have a chance of infusing some of the experience. There will be engagement, because they are here with us, sharing our experiences and skills with them. It requires more thought. It requires thought, Commissioner, but that's the basic idea. And there's absolutely no reason why, well, it's something that we are doing now, that the magistrate does not rise through to the High Court, through to the SA, which we've achieved, by the way. I have 2 women magistrates at the SA who are doing well, and all the way to the Constitutional Court. So that is something I have in mind. I know my response is vague, but that's the general idea, that we get there. But it needs thought and debate. Of course, I would not be making these decisions alone, and I don't have all the answers on my own. I would need the input of other interested people, including my colleagues. But that is the idea, the general idea.
And do you think that the type of training that the universities are currently doing is satisfactory to provide the lawyers of the future?
Unfortunately, no.
Could you elaborate? Where would you see different changes taking place? What type of things would you change?
It's something that's been in the debating circles for a while, that this LLB, for a long time now, this LLB is not producing the caliber of it's just not enough, the caliber of lawyers that we deserve, and even those holders of those degrees, deserve. And I tend to be conservative. I don't see anything wrong with how we used to do things. So maybe we don't have to reinvent the wheel here.
Thank you, President.
Thank you.
Thank you, Chief.
Thank you, Professor
May I make a follow-up, Chief, just on this one?
Please do, Commissioner.
No, it's only on this issue of the LLP. If you recall, we agreed on this integrated LLP simply because we had fewer numbers of black practitioners way then at the time. So one of the things you integrate the 6-year LLB program, PPROC, into congested 4 years, and then it lacks with the practical and all that. So I'm asking, I want to find out if one can introduce an element of practical within the LLB training as a course. Don't you think that the situation may impact?
Yeah, that could help, Commissioner. That could help a lot, actually. But you know, the irony of the situation is that we sit with an influx. I mean, a whole lot of LLB graduates who can't even find articles. So that idea it has not yielded the result that was hoped it would.
No, I agree with you. It was not a good one. We just need to revisit it. It's Prof here and us at the law society. No, thank you, President.
Thank you, Commissioner Nakesi. Commissioner Breitenbach will be joining us virtually.
Thank you, Deputy President, and good afternoon.
Good afternoon, Commissioner.
How are you?
I'm fine, thanks. How are you?
Well, thanks. You must be quite tired.
I am indeed, so I hope you'll go easy on me.
Yeah, probably. A couple of questions ago, you said in reply to I think a follow-up question, why women in general, but probably judges, weren't being given, plum cases, difficult work, niche work, and you said, people needed to trust them, trust women. Just trust them, and then they can do the job. And I absolutely agree with you. Of course, they can do the job. There can be no doubt that they can do the job, and you are the living embodiment thereof. So, who are these people who don't trust women?
It's the men. Remember, I said they are the field. They control. In fact, they don't just control the field; they are the field. So they are the ones who hold the power strings.
Yes. And men keep on saying, empower women and treat women well, but they continue to have this patriarchal approach. Men who don't trust the women. So how do we address that?
I'm afraid I don't have an answer for you, Commissioner. I mean, we can only do our best, do the work which we do. And if that's not enough to convince people that these people are capable, what more can you do? Well, I suppose we can toy and...
And, men constantly suggest, and on this panel as well, on the JSC, suggest to men, and you've sat on a panel when they've done it, as have I, and it really does, I suppose, irk me. They suggest to men, why don't you withdraw from this race so that, a black woman may have a chance at this job? I find that particularly patronizing, to suggest that in order for a black woman to be able to compete, she shouldn't have to compete with men.
Yeah.
How do you feel about that?
Yeah, look, I don't think there's any... Actually, it's intended to... I think they believe it's to assist us. You have to be at the receiving end of these things to understand just how they impact you and your group. So I don't hold it against our male colleagues. They think the intentions are good, but the impact is not at all, at least on us women. Because when we come here as candidates for that job, candidates who happen to be women, which of course is something to be taken into account, but that's not our card that I'm a woman, so give me this job. No.
You don't need any favors. You're capable of competing on your own.
Exactly.
My second question, President Meyer, is if you are appointed, you will head the judiciary, and you have really good ideas about combining the lower courts with the superior courts. The problem remains that the courts are not functioning well. Your court excluded, of course, and the Constitutional Court's doing better, but generally speaking, the courts are not doing well. Court hours are low, finalization rates are bad, and there are many reasons for that, none of them good. we now have got the second Zondo report, and again, there are many prosecutions recommended therein. And it doesn't only depend on the police to investigate and the NPA to prosecute. They need courts to do it in.
Yeah.
How do you see the courts dealing with this deluge of cases that are going to be coming our way? Do you have any suggestions about how those should be dealt with?
Well, I'll start with, I believe in working with what you have, and our situation right now, as you know better than I do, is not a particularly good one financially. You'll recall I said when I spoke on my vision that there are actually a number of high courts, Commissioner Breitenbach, that do well. And what one sees is that they do well because there's firm leadership there. If you have a good person at the top who is not afraid to, to chase colleagues to do what they signed up to do, then you're not likely to have problems. We have case flow management systems. We have norms and standards. Now, if leaders understand their responsibility to ensure, is set out in the Superior Courts Act and elsewhere for the magistrates, and they do their job and ensure that their colleagues, well, it starts with the Chief Justice, I suppose, who has the oversight of the entire judiciary. The Chief Justice should worry when they hear that the magistrate in Palm Ridge, the Chief Magistrate, maybe Commissioner Makwanisha went to visit the court and found that at 11 a.m., no one was sitting, but people were milling around in their offices and in the corridors. Someone has to crack the whip, but that's what it takes. So in short, we know that because there are high courts that are already performing well now, and the distinguishing factors between them and the ones that are not producing the required results is firm leadership and following, the procedures that are there for judicial officers, on how they should execute their functions, then we need to follow up on that. But you make a point that there's likely going to be a deluge of these cases, and I don't think even with the best intention and, best work output, the present courts can cope. Well, I'm speculating. One doesn't really know how many cases will arise. But if things should come to a point that the existing courts are not coping, then money on the broke country or no broke country, minister, something has to be done to establish courts that can deal with those cases, because it's important to act on the report. Thank you, Commissioner.
Thank you very much, President Moore.
Follow up.
Thank you, Commissioner Breitenbach. Follow up, Commissioner.
Thank you very much, President, for the response on the question of withdrawal. But is it entirely correct that this body tells a man to withdraw in favor of women? Because as a member of this body, you will know, President, that there are men who are told to withdraw because they are just coming across as being extremely incompetent and embarrassing this body. And one such man is Judge, was it a Judge Bushielo from Northwest? I think he's late now, may his soul rest in peace. But he was asked here to withdraw, and it was not in favor of a woman, but it was on the basis that their performance or issues that get to be raised are such that they should have used their conscience to stay out of this process. So, and secondly, this body has actually told women who came across limited to withdraw.
Oh, yes.
Yes, so to create an impression that men are being told to withdraw in favor of women is not entirely correct.
I agree with what you've said, Commissioner. Well, Commissioner Breitenbach is here, and I have no doubt that she can defend herself, but I'll say what I understood her to mean. I thought, because I have had, I've had it here over the years being suggested, being asked of males why they have applied when there's a woman and the demographics. I can't remember the particular facts offhand now, but it has happened. And the suggestion was that why are you here? Why did you not pave way for this woman? And the point we are making is that we understand that actually that's meant in very good spirit. It's meant to promote the cause of women. But women don't appreciate it. We don't want to appear like we're asking for handouts. We have our own pride, you know. That's what I thought she meant. That's how that question makes me feel, at least speaking for myself.
Thank you, Commissioner Malema. Commissioner Barnett.
Thank you, Acting President. Good afternoon, President Meyer, once again. I'd like to start focusing on the role of the Chief Justice as Chair of the JSC. So, and just maybe to start with, to make a statement that you already, to an extent, give some leadership in the JSC, where, for example, you chair a committee or committees. Perhaps you can give your own account of your experience in that regard to the Commission, and how things are going there, and how that would be able to assist you if you were to be appointed as Chief Justice. What would you be able to draw on?
I'm sorry, Mr. Bernard. I missed a huge chunk of the question. Can you just repeat it for me?
Sorry, your role as Chair of Committees in the JSC, that has already been taking place for some time. So
yes.
Just what experience do you draw from that, just to maybe inform the Commission on that, and how you will draw on that, or how that might be able to assist you if appointed in the role of Chief Justice?
Oh, thank you so much, Commissioner. Oh, well, I have chaired, remember there was a gender subcommittee that was elected to draw a response to the CGE, the Commission for Gender Equality report. I wonder what happened to that, by the way. And I was elected to chair that subcommittee, and got an opportunity to work closely with a few of the commissioners. And then there's the screening committee, of course.
Sorry, Chair, there seems to be a loss of sound from
He's back.
The power seems to be back on.
Yeah.
Yeah, we can continue, I'm sorry.
I don't see Commissioner Bernard. I don't know if you can hear me.
Commissioner Bernard, can you follow the conversation?
I can hear now. There was a slight break of sound, but it's all back on now again.
Yes, it's because there was load shedding earlier on.
Can you hear me, Commissioner Bernard?
I can hear you. May I proceed, please?
Okay. Thank you. I was explaining the roles I've played in the internal structures of the Commission. The experience I got there really was just to get deeper insights into the responsibilities of the Commission. Let me just hasten to point out, Commissioner Bernard, that I chair a lot of bodies. So, and chairing one committee is pretty much the same as chairing another. It's bringing organization, I mean, just bringing order and organization to the proceedings. There's nothing extraordinary about that. I don't think I've gained more from sitting there. It's just been more work for me than the experience I get from sitting in the big JSC.
But I think it helps you with the internal workings of the JSC to a certain extent, except that you obviously sit there as the president of the SCA as well.
Yeah, I agree.
Now, on transformation and modernization of the JSC itself, it sits with, for example, criteria for aspirant judges that have been determined and published some years ago. There's been some press about that. And this is despite the fact that one knows over time things have changed in the judiciary and so on. And so there might be need for changes regarding that, since those criteria were worked out. And then the way meetings is held has notably changed over the last couple of years, partly due to the COVID, the pandemic and the online type of meetings. And then we also know that the JSC mandate is wider than just appointing judges. For example, I'm thinking specifically of the advisory role that's set out in the Constitution. So what is your vision for the JSC in general, and more specifically with regard to these aspects that I've now highlighted?
Well, in addition to those aspects you've highlighted are the proposals that have come from interested parties, about the manner in which we conduct our business, just to coin it crisply. My short answer, Commissioner, would be that I'm hoping that the meeting the body has undertaken to have shortly will just review everything, and then ideas can flow from there. I don't really want to venture any opinions on that at this stage and here. It's just safe to say that the JSC intends to have to do an introspection and look at these processes for the benefit of interested parties who may wonder if we were even listening to them.
And then if one, just moving on to a different aspect now, and that's just the Office of the Chief Justice, if appointed, thinking about yourself, what would the weaknesses or perhaps blind spots be, and how would you counter those weaknesses or challenges that you might face if they're not weaknesses?
You mean in that department?
No, I mean in respect of yourself to deal with that department.
Oh, well, the most obvious thing is that I've only ever led the Supreme Court of Appeal, which is a small court with 25 judges and 68 support staff, and that's a huge institution. I mean, the entire, now you're scaring me because you're forcing me to think about the enormity of this job, because it's not just the OCJ, it's all the other things that the CJ, the Chief Justice, is responsible for. It's a big job. But as I said, when I outlined my vision, there's a lot of support around the Chief Justice. We've seen it. I've seen it at play, at least in my time in the Heads of Court cluster. The OCJ plays they truly play their part. They offer the support. I have no doubt that they would put me through yeah, I'm sorry, English is my second language, and when I get tired, it just escapes me. I have no doubt that I would have the necessary support. I'm a quick learner, I must say, and I have a very strong character. So I would be able to manage whatever challenges came my way. But with that kind of support, I'm sure I'd quickly come to grips with everything that comes with the job. I'm ready for that.
Thank you. And then if one just thinks of your role as leader of the judiciary, and one thinks about Section 165, which gives the Chief Justice responsibility over the judicial functions of all courts. Much of what has been said today deals with higher and magistrates' courts, yes, and let's call it the more commonly known court system. But then section 166E defines judicial system to also include any other court. So, and that when they, you know, in the context of other than the higher and the magistrates court. So then, could you just discuss your vision as Chief Justice regarding these other courts? One example mentioned already was earlier by you, the small claims court and so on. But in general, what would your vision be for these other courts?
Well, I don't have a defined vision at this stage, Mr. Bernard. I mean, as I said, these courts, by and large, wallow out there. They are the forgotten stepchildren. But one thing that rings in my mind is that we need to bring them into the fold, and then we'll take things from there. I've read up on them on the internet, and I don't think that is enough. One needs to actually engage with those institutions physically to have a real experience of exactly what goes on there. I can't draw a vision on what I've read from the internet and anecdotal accounts from people I've asked about the operations there. But my key thing right now is to bring them into the fold and then get to know exactly what's going on. And with the assistance of my colleagues, we'll make the necessary plans to do whatever is necessary to give them support or whatever is needed.
Thank you, President Meyer. Thank you, Acting President.
Thank you, Commissioner Barnett.
Quick follow-up, please, Acting President.
Yes, you may
Thank
proceed,
you. Yes,
Commissioner Bof.
Thank you very much. A very quick one, President. I was just reminded by one of Commissioner Barnett's questions. As you know, that in October, this JSC, of which you were a part, agreed to have a workshop of the JSC, particularly because there are new commissioners and so on, but also to try and streamline how we work. The view which I shared, or at least expressed, was that that should be rather done when there's a new Chief Justice with that person, because that person will be chairing the JSC going forward. And that seems to be what has happened. Now, if you were appointed, would you be keen or able to convene such a workshop as soon as possible, if possible, even before the April sitting, so that, going forward with the new Chief Justice, we would basically be moving from the same page, so to speak?
The sooner the better, Commissioner. That's absolutely, it has, whoever gets the job must be prevailed upon to do that. We can't afford to wait.
Thank you. Thank you, Acting President.
Thank you, Commissioner Bofu. Commissioner Matolo, your hours come.
Okay, thank you, Acting President. Justice Meyer, I greeted you earlier on.
Yes, good afternoon again, Commissioner.
Yes, and I've been waiting so much for this opportunity, and I thought I'm too far below to ask you some of the questions. But what I must say that I really appreciate you having availed yourself. It's actually affirming the role of women in our society. One of the things in your vision, you had a lot of issues that you raised about your vision, and what I just wanted, maybe if you could add on your vision, is to the interaction with the professional and stakeholders. I'll tell you why I'm saying that, in the sense that we have this, whether it's 6 months meeting with the heads of court, where we meet with public works, everybody's there. And for me, they haven't served the purpose they're supposed to serve. Because I always feel it's a talk shop. There's no monitoring of what the issues that are being raised. Yeah. For instance, the profession will raise issues of the operations of the court. There are frustrations. But come next 6 months, it's still the same. So I think those are the things that you should really put they are called PEEC meetings or NECC meetings, But they always happen, but there's nothing that monitors. I mean, public works will be defending themselves, so and so is but nothing comes out of it. Can you just prioritize that so that at least we move together with the profession, because the courts cannot work without the profession. And those are some of the challenges that the profession is experiencing. And the lifts not working, the air conditions, and it will actually even assist you as judges, you know, if those things are implemented. The second issue is just a follow-up on the issues of, the briefing patterns. I know that a lot of people raise that issue, and I want to assure you that as a profession, we have done our best. We have come up with the legal sector code. We had the support of the Department of Justice and the ministry, but it's sitting somewhere. You know, when executives, it's sitting somewhere in the DTI and it doesn't move. For me, the bottlenecks, I think they are here, they are listening, the bottlenecks that happen in between the executives themselves, it becomes a problem. Because we thought by now the monitoring council will be in place so that we see that whether it works or not. Yeah. So I think I just wanted to you know, I'm behind you. That's my passion. But the executives must assist us to make sure it happens. The third one, that was a follow-up. The second one, I wanted to, not in defense of the BLA, but I'm just saying the issue of acting judges. There's a perception out there from the profession, so that because the acting appointments comes from the JPs, you know, you get invited. And some of the JPs, when you submit names, they said, wait for me, you shouldn't come to us. And this is where the perception of saying favoritism and all that comes from, you know. But I remember we had suggested to the minister a policy on the acting appointment so that we participate as a profession also, submit names, so that at least people shouldn't be seen as being overlooked, you know. So I just wanted you to at least to be assured that if we suggested a way forward for acting appointments, even, we shouldn't be calling just this JP Tlaleti, hey, can you assist our members, you know? At least there must be a policy. So I think that's what I wanted just to, we understand the perception is all there, so we need to deal with it. I think the third one, for me, the first one was clarity. Ne? the third one is, for me, I understand that, for instance, Commissioner Mpofu and Justice Matopo, they are mooting this idea of merging the two courts. And for me, I'm not sure, I just want to know your take on this. I understood the Constitutional Court to be there to develop our law, deal with constitutional issues, but more and more I see it being packed with appeals and appeals and appeals, you know. And I still feel that, I may be wrong, we haven't developed the South African law in terms of our constitution to suit South Africa. We still refer to Roman Dutch law, to the common law. If we merge the two, aren't we eroding that part of us developing our own South African law? That's what I just wanted to hear from you.
There are 5 points, and my response to points 1 to 4 is all noted, Commissioner Lepu. And if I'm appointed, you can be sure that I'll do something about them. Now, about the last, just remind me, what was the last one? Just a keyword? Oh, the collapsing of the two courts. Yeah. I don't know if using the two courts would dilute anything. The two courts apply the same law, Commissioner. And I think the real issue is the increasing of the jurisdiction of the Constitutional Court. And we will see you know, in fact, that's why I was even suggesting getting more judges, or so that you could have two panels, because you have a stream, sort of two different streams of cases, the more generalist cases that still end up there, and the truly constitutional matters. So I think the two-panel solution might deal with that. But as for your fear, your concern that doing away with the SCA does not apply its own law, it's bound to apply, like the High Courts, the Constitution and the law. So they do the same thing. It's just that there are certain powers that the High Court and the SCA don't have. The declaration of constitutional invalidity, for example, only the Constitutional Court can confirm, you know, small, well, not small, things like that. I still find merit in the idea of using the two courts. But it does not have to happen now. It could be a medium to long term, well, or even short term goal. Yeah.
Okay, thank you, Judge Acting President.
Thank you, Commissioner Matolo Lepu. Commissioner Malema, I seem to recall that you said you no longer have any questions.
I didn't say anything.
Do you want to say something now?
Yes.
Please do.
No, I'll be very brief. I just have two questions. President Mai, earlier on you spoke about perception being the most important thing in the judicial. This thing of judges going to houses of politicians, and when asked about that, they say no, they went to discuss matters of national importance with politicians, which they can't take the country into confidence, meaning a judge and a politician have got some secret that they can't tell us about. Does it help to enhance the good image of the judiciary, or is contributing to what Commissioner Singh was talking about of lack of confidence, which is growing amongst the population because of those types of characters that we find amongst ourselves?
That's a tough one, Commissioner Malem. Let me first say this. In Bloemfontein, I was neighbors with the Premier, the former Premier, just 10 minutes apart, our houses, for about for the length of his tenure. If I was driving out of my house and I saw his entourage, you know, leaving, I would turn back. I literally ran away because I was scared of, I didn't want to meet him. The one time I met him was during, we were interviewing for, I think about 4 years back, interviewing for a vacancy in the Bloemfontein High Court. I met him at the tea. I did not even introduce myself that, you know, we're actually neighbors. So I'm afraid of things. That's a literal translation from isiXhosa. But to answer you more directly, look, I can imagine a few instances where a head of the judiciary would have private business with well, not private, sorry, official business with the head of state. I imagine that if, for example, about recommendations of the JSC, it's not the president who would, if the president commanded the Chief Justice, well, not commanded, asked the Chief Justice to report at his home to discuss those recommendations, there would be nothing untoward with that kind of meeting at the president's official residence. I don't know about the privacy of the I mean, why it would not be disclosed. I can't really say anything about that. If it were me, if I went to attend that business, because that information belongs to the public anyway, so we serve the public. I would disclose it, that I actually went to see President Ramaphosa to discuss the recommendations of the JSC. He had asked me to visit him. But I don't know, I can't really comment intelligently when I don't have all the facts. I don't know what that was about.
In 2010, we had, during the World Cup, we had special courts that were dealing with those matters of related to. Sorry, President. And before I move there, I just want to agree with you that from time to time, you, as head of court, you'll meet, or as a judge, whatever, you'll meet with the leadership of the country. But when you are asked, you'll be able to say, I went there to discuss the recommendations of the JSC. But once a judge comes across as saying, we want to discuss a matter of national importance, and then you don't want to disclose to the country as to what is that matter, it means a judge can have a secret with a president or a politician. It's a worrying factor. But moving to the next one, 2010 there were special courts. Why are we not creating special courts to speed up matters of corruption? For instance, we had a commission here that was investigating corruption. And in the two reports that came out, nothing came out except to recommend a further investigation. After spending 1 billion, we're still furthering another 2 billion, another investigation. If there was an alarm like those matters were referred to that commission, there's corruption in Transnet. These are the people who are responsible. The same recommendation, you don't need a recommendation of a commission to investigate a crime. Now, we are told after 2 billion, we must still investigate further the possibility of a crime. So, instead of commission, shouldn't we have special courts dedicated to corruption? So that once an investigation is done, then the decision is taken to prosecute. You have a court that is dedicated to this corrupt matter. I will tell you why. This matter of corruption is a big problem in this country. And it must be attended specially and urgently the same way we did in 2010. Shouldn't we, if you are appointed, are you amenable to consider some special court to attend to corruption cases so that people begin to see that we are serious in dealing with corruption and finalizing the corruption cases as soon as possible in order to then send a message to society that if you engage in these things, you're going to be caught and you'll be sent to jail for a very long time. That is one reason. But the second reason I'm raising this matter is, which you may not have to respond to, corruption cases are now used by those in power to settle political scores. So they just taint people, pretend to be taking them to court, and they leave them there hanging for so many years with a dark cloud, so that these people are not a threat to their office occupation. So I think that perhaps, I don't know, you'll guide me there, President, have we not reached a point where we need special courts to deal with matters of corruption as speedily as possible so that the country and the world can see that South Africa is serious in dealing with these matters of corruption?
I think every right-thinking South African would agree that that's a fine idea. But I don't know if we'd be able to create such courts within the resources we have now. I mean, the courts are currently struggling with their workload. We are short-staffed. I mean, we all know what's going on. I guess it would depend on whether the minister, if the idea was posited to him, the proposal was posited to him, did not come back with the usual answer that Treasury says there's no money. The country was not broke in 2010, Mr. Malem. So.
Thank you, Commissioner Malema.
Follow up on that one, Acting President.
Yes, you may proceed, Honorable Minister.
Yeah, thank you. Maybe on that same question, President, just to expand on it. Shouldn't the specialty start with the investigation and also with the NPA? And also to say, the crimes we have now, that some of them you might have seen on appeal, can we still really say there is no convergence between investigation and the prosecutorial role? The complexity of the matters, the way we have them today. And I think what comes to mind to me, which at least at the time, which was foresight, was something like a DSO that had some powers of investigating and cushioning, and also in terms of, now what we have is a situation where the Hawks or the police investigate, takes time, they give the NPA tells them to go back to look at this and that, takes another time. By the time the matter goes to court, it's 3 or 4 years, and sometimes there's no indictment after 6 or 7 appearances. So that is the kind of question I'm asking, that shouldn't that be the kind of thing we're looking into, so that we're able to have matters being investigated quickly, being prosecuted quickly, and also if, for example, with the Special Commercial Crimes Court, if it is then overwhelmed, there's a basis to say we may create a special role or we may create a special court as per the suggestion of Commissioner Malema. But if we do it now, there's no case that the Special Corruption Court will do. So that is a kind of question I'm having. What will be your view? I mean, the Glen Vista case states the requirements of a kind of corruption-busting institution, what are the powers and all that kind of acting president.
You are making sense, Minister. You are making sense. I don't see any contradiction between what he proposes and what you are saying. You are just beefing up the process from inception now, from investigation. But his idea remains that specialist courts will be needed for a few reasons, few good reasons. But what you say also is they should be combined, and with that composite mechanism, I'm sure it make great inroads into this cancer that has brought our country to its knees.
President, may I just follow up on this as well? It's me, this side, President, just quickly. Can I follow up on this quickly?
Yes, please do, yeah. Commissioner.
President, the point is, I think the idea of the NEEC introduced by the Chief Justice is something that one would keep those institutions, strengthen up, because what Commissioner Malema is saying here, to me, is one of the issues that makes people, the public, to lose confidence. Particularly with these cases of the ANC step aside, they are putting all of them in jail every day, with cases to stay there 8 years. I have a case in the Eastern Cape. It is 8 years, the Mandela case. It has nothing, we can raise it to you, but if we took them to that NEC, we track on the cases, what is the reason why it is remaining there, at least there would be, other than the institution which needs to be polished up, but from the court's point of view, a mechanism, because we owe it to those who are accused, a duty that these matters are finalized, also to the country, corruption that it is dealt with. This is a balanced approach.
I hear you, Commissioner.
Follow up.
Commissioner Singh.
Yeah, thank you very much, Acting President. President Maya, we all know of the saying, in for a penny, in for a pound. Now, we've spent so many pennies, that's gone to over 2 billion rand, as Commissioner Malema has said. Now, surely as a country, we can find resources somewhere to ensure that we follow through logically on prosecuting the people that have been involved in this corruption, because at the end of the day, it's going to benefit the country as a whole if these people are put behind bars and in orange overalls, and we'll have more money and there'll be more confidence, not only in the judiciary, but confidence in the country itself for foreign investors, etc. There was a time when I read, and correct me if I'm wrong, about funding being made available from outside sources, for these kinds of prosecutions, or to beef up the judiciary. I don't know if you're aware of that, but I think I did read somewhere. Yes. And I don't know what your view is on that kind of thing. Because, I mean, we've got funds that we get from IMF, from World Bank, from everywhere else. I mean, what would your view be on that?
Well, I think, look, the principle, I agree with the principle as a taxpayer, South African, but the other logistics I would leave to Minister Lamola and Treasury. I don't know if I don't know how those work, getting funding elsewhere, and if maybe we can't find resources from our broke bank account. But I agree with the principle as an ordinary South African.
Acting President, that's me.
Commissioner Malema.
No, the reason why we're raising this issue is because if you are a head of the judiciary, you are going to inherit this, I don't want to say bad image or lack of confidence by our people on the judiciary because of how long we take to resolve some of these issues, which are a big problem for our country. So in as much as we don't have a budget, but an idea that is put in a very structural manner, so that even tomorrow we get money somewhere, we're able to say, okay, this is how we're going to move towards making sure that we restore the image of the judiciary. Many of women don't report rape because it takes forever to just resolve it. And the humiliation of going through and coming back and going, I want to deal with this pain and deal with it and finish it so that I can reclaim my life. But there are no specialized courts that deals with these fundamental issues that are confronting our people. And I think that it's a point that perhaps you need to consider when appointed.
Thank you, Commissioner Malema. President Maya, I've got a few propositions that I want to put to you.
Yes.
For your comment. The first one is, if you were to be appointed the next Chief Justice, do you think that the environment would be conducive for you to replicate the many positives that you achieved at the SCA at all levels within the judiciary?
Yes, Chair. I have no doubt that that's eminently possible with the support of my colleagues, of course, who I know also have the best interests of our institution at heart.
Thank you. Earlier, you did mention that you are firm, and I think your firmness was put to good use at the SCA several times, because whenever problems arose, you were courageous enough to nip them in the bud.
It is a characteristic of my clan, especially the women of that clan. Okade, intombi zakwaRhadebe ziyaziwa tiphi.
Then the other issue that I want to raise with you, you know, when I read the comment from the BLA, especially the second last or penultimate paragraph, unnumbered, of their comments, page 3, where they say, you know, during 2017, 18, 19, 20, the acting appointments at the SCA favored white males. And this caused me to check my records. And I observed that during your stewardship, from April 2018 to April 2021, 13 judges were appointed to the SCA, 2 white males, 1 white female, and 10 black judges, 6 of whom are women. And the point that I want to put to you is that the concern raised by the BLA seems, in my view, to quibble about acting appointments and overlooking an important consideration relating to permanent appointments over the same period at the SCA. South African judges come from various backgrounds, and you did earlier on when Commissioner Nokiesi put some questions to you, gave us an insight of some of them. But what I want to put to you is that regardless of their past affiliations, be they political or otherwise, judges are always expected to be scrupulously faithful to their oath of office and to decide cases that come before them with integrity, courage, by applying the law to the facts of the case.
Yes.
Thank you. And the other issue I want to put to you is that in my view, it is an illusion to think that this Chief Justice is a supernatural person with monopoly of wisdom who will have answers to every challenge that might confront the judiciary.
Yep.
And that an astute Chief Justice will recognize the fact that within the judiciary, there will always be judges with special skills, talents, and indeed leadership qualities. And the Chief Justice would then be well advised to tap on those talents in taking the judiciary forward.
I couldn't have said it better.
We are almost at the tail end of the interview. Do you have anything that you would wish to say that may, in your view, be of assistance to us during our deliberations before we adjourn for the day?
No, DP, I'm going to disappoint you. I don't have a closing statement. I think I've said enough here. All I want to do is to ask for an opportunity to thank all the people who nominated me and supported my candidacy, especially the women. Women are notorious. One of the commissioners mentioned this. Women are notorious. I think it was Commissioner Malema. Women are notorious for not being able to support one another, but in this case, well, and in other cases too, but we're here now, in this particular case, they moved heaven and earth to ensure that my name becomes, well, not my name, I'm the guinea pig, if I may put it that way. A woman gets an opportunity, to be considered for this, such an important job. And it's such an honor for me to be that woman. And whichever way the decision goes, I will remain forever grateful for this opportunity to all those who made it possible. I think women have, Commissioner Lucas said it, we've broken, we've just caused yet another crack in this glass ceiling just by having a woman come in and sit here for these kind of proceedings. This is a huge victory for women, just being able to sit here and address you. So I'm thankful for that opportunity. And those people almost crashed my phone with all the messages of support. Thanks to them all. That is all, DP. Thank you. And commissioners.
Well, it remains for me to thank you for availing yourself and for your candid answers to the questions that were put to you by the commissioners, which will no doubt be borne in mind during our deliberations. You are at this stage excused.
Never thought the moment would come.
Thank you.
Thank you so much, and good luck with the rest of the proceedings, commissioners.
Thank you. Fellow commissioners, this then concludes the business of the day. Shall we then resume tomorrow morning at 9 o'clock on the dot?
Sorry, I'm sorry, Acting President. There's just a small issue I wanted to raise. If we can let the media leave. It won't be more than 5 minutes.
Mr. Chilane, will you please ensure that the venue is cleared and only members of the commission remain? Thank you.